ಯಾವುದು ಕ್ಯಾಮ್ರಾ ಕಾಣಿಸ್ತಿಲ್ಲ
ಮೇಡಮ್
ನೋಡಂಗಿಲ್ಲ
6ನೇ ತಾರೀಕು
ಎಷ್ಟಾಯ್ತು ಅದು ಸೀರಿಯಲ್ ನಂಬರ್ 2 ಥ್ಯಾಂಕ್ ಯು ಸೋ ಮಚ್ ನಾನು ಹೇಳ್ತೀನಿ ನಮ್ಮ ಇವರಿಗೆ ಅಸೈನ್ ಮಾಡಿರೋದು
6ನೇ ತಾರೀಕು ಗೊತ್ತಾಯ್ತಾ ಮೇಡಮ್?
6 ಗೊತ್ತಾಗ ಮೆಮೊ ಮಾಡಿರೋ ಡೇಟ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳ್ತೀನಿ ಇದು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಇದೆ ಅಂತ ಹೇಳಿ ಕಳಿಸಿ ಯಾರು ಅಲ್ಲೇ ಹೋಗಿ ಹೇಳಿ ಅಂತ ಹೇಳಿದ್ದೀನಿ ನಾನು ಅಲ್ಲಿ ನೋಟಿಸ್ ಸರ್ವರ್ ಮೇಲೆ ಲಿಸ್ಟ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ ಅದಕ್ಕೆ ಅದೇ ಹೇಳ್ಬಿಟ್ಟು ಅಲ್ಲ 2 ದಿವಸ ನೀವು ಅಲ್ಲೇ ಕೇಳಿ ಮಾಡ್ತಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ ಆಮೇಲೆ ಬೆಳಿಗ್ಗೆ ಒಂದು ಸ್ಟಾರ್ಟ್ ಕಾಣಿಸ್ತವೆ ಇದು ಕ್ಯಾಮ್ರಾ ಇದೆ ವ್ಯೂನೇ ಬರ್ತಾ ಇಲ್ಲ ಪ್ಲೇಸ್ ಇದೆ ಕರೆಕ್ಟ್ ಇದು ಟೋಟಲ್ 20 ಇಂದ ಎಲ್ಲರೂ ಸ್ವಲ್ಪ ಅರ್ಜೆಂಟ್ ಕಳಿಸ್ಕೊಡಿ ನಿಮಗೆ ಈ ಕ್ಯಾಮ್ರಾದ ವ್ಯೂ ಬರ್ತಾ ಇಲ್ಲ ಅದಕ್ಕೆ
ಮುಂಚೆ ಬರ್ತಿತ್ತು ಅದೇನಾದ್ರು ಇದು ತಗೋಬೇಕು ಪ್ಯಾಟ್ರನ್ ಏನಾದ್ರು ಚೇಂಜ್ ಮಾಡಬೇಕು ಅಷ್ಟು ಬೇಗ ಮುಗಿದು ಕೆಲಸ ಆಯ್ತು ಅದೇ ನೆಗಡಿ ಕಣ್ಣು ಹಿಂದೆ ಕಾಣ್ತಾನೆ ಸರಿ ಹೋಗಿಲ್ಲ ಅದೆಲ್ಲ ಕ್ಲಿಯರ್ ಬ್ಲಾಕ್ ಬೀಡ್ಸ್ ಅದು ಡಾಲರ್ ಇಟ್ಕೊಳ್ತಾರೆ ನೀವು ಕಮ್ಮಿ ಆಗಿ ಕ್ಯಾರಮೆಲ್ಲ ಹೇಳ್ತಿದ್ರಪ್ಪ ಇನ್ಸ್ಟಾಲೆಲ್ಲ ನೋಡಿದ್ದು ಯೂಸ್ ಮಾಡೋದು ಈಗ ನನ್ನ ಎಕ್ಸಾಂಪಲ್ ಮಿಸ್ ಮಾಡಿದ್ರು 1 and 2 ನಮ್ಮ ಹೆಂಗಿದ್ರು ಇವಾಗ ಹಿಡಿತಾರೆ ಎಲ್ಲ ಥರ ಪ್ಯಾನಲ್
ಪ್ರಶಾಂತ್ ಫೋನ್ ಮಾಡ್ಬೇಕಂತ
ಅವರಿಗೆ
ಪ್ರಶಾಂತ್
ಪ್ರಶಾಂತ್
ಇದು ಕ್ಯಾಮ್ರಾ ಬರ್ತಾನೆ ಇಲ್ಲ ಮೊದಲು 2 ತೋರಿಸ್ತಾ ಇತ್ತು ಈಗ ಜಸ್ಟ್ ಒಂದೇ ತೋರಿಸ್ತಾ ಇತ್ತು ಆಮೇಲೆ ಮೇಡಮ್ ಸಿಟ್ಟಿಂಗ್ ಇರೋದು ರಿಮೂವ್ ಆಗಿದೆ ತಾನೇ ಲಾಸ್ಟ್ ನೋ ಸಿಟ್ಟಿಂಗ್ ಅದೇ ಡಿಸ್ಪ್ಲೇ ಆಗ್ತಾ ಇತ್ತು ತುಂಬ ದಿನ ಒಂದಾಯ್ತು ಇನ್ನೊಂದು
ಮಲ್ಟಿ ಕ್ಯಾಮ್ರಾ ಬರಬೇಕು ಮೊದಲೇ ಬಂದಿತ್ತಲ್ವಾ ಫಸ್ಟ್ ಬಂದಿತ್ತು ತಾನೆ
ಸರಿ ಹೋಯ್ತು ಮೊದಲು ಹೈಟ್
forward the various ನನಗೊಂದು ಅದೇ ಪೆಂಡಿಂಗ್ ಇರೋದು.
ಡಿಸ್ಪೋಸ್ಡ್ ಅಲ್ವಾ?
ಕ್ಲಿಯರ್ ಆಗುತ್ತೆ ಇವಾಗ. ನನ್ನ ಸ್ವಲ್ಪ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಕರಿಕತ್ತೆ ನಂಬರ್ ಹೇಳಿ ಇಲ್ಲ ಇದ್ರೆ ತಕ್ಷಣ ಹೇಳ್ಬಿಡ್ಬೋದು. ನಿಮ್ಮ ನಂಬರ್ ಬಂದರೆ ಹೇಳಿ ಇಲ್ಲ ಅಂದರೆ ಅದು ತಕ್ಷಣ ಮುಗಿದ ತಕ್ಷಣ ಹೇಳ್ಬಿಡೋಣ.
Any memos?
My lordship, being spoken to my lordship, right? My lordship, on the last, on 19/1, my lordship, I filed a memo that concerned that in that petition, there are 3 accused, my lordship. They have approached this court. In the order sheet, only 2 accused were mentioned, my lordship. I verified that against the accused number 3, trial court has closed the trial, my lordship, since he was a juvenile, my lordship, at the time of trial, my lordship. At the time, and I saw that in accused number 1 and 2 have been acquitted. On the same basis, I filed the memo, my lordship. Now, accused number 3, against accused number 3, different crime number is.
Proceedings are pending now.
Please, my lordship,
Against,
before the JJ board, my lordship, not
JJ.
in the same.
It is still pending.
Please, my lordship.
File a memo. I have served the notice on the other side.
Other
Who is
side,
for the petitioner?
that day also they did not appear. I tried to contact my lordship. I couldn't.
Yes.
Any adjournment? List 2, page 1, serial number 5.
Lord, serial number 3, may I make? Serial number 3, may I make a mention? It's for further arguments. There is a bereavement in my family. I may need to go out.
No, list number 1.
Number 2, court officer, list number 2. Serial number 3, it's for further hearing. There
Serial
is a
number
bereavement.
3.
I am for the respondent, number 2.
Okay. Who is for the petitioner? Dhananjay Kumar.
Lord, there is a bereavement in my
Yes.
family, my lord. I need to go out. That's it.
For respondent number 2, place for time.
Would it be on Monday?
On the ground that there is bereavement in his family. List of. Yeah, our date code. Yes.
Anything?
Yes, next.
Page 2, serial number 6. List 1, page 1, serial number 1. Mohammed Pasha.
My lords, list number 1, serial number 5, my lord. Senior is out of station, my lords. Due to it, I need a short accommodation for that. my lords.
So representing whom?
Petitioner, my lords.
Petitioner. Then who moved the memo? At whose instance the petition is listed?
Yes, kindly, my lord, senior,
Respondent. Nagaraj Reddy. Counsel for the petitioner placed a time. From counsel for the respondent has moved the memo for listing. Counsel for the petitioner undertakes to address the arguments on the next date of hearing, list up. Next.
With
Yes.
the honor's kind permission, list 1, serial number 8, my lord. The matter has been moved by the respondent. I appear for the petition in the case, my lord. I have spoken to the counsel for respondent, seeking for a kind accommodation. Could the matter be taken up next week, my lord? I've already intimated the opposite party.
Same.
It could be taken up on the 13th of February, my lord.
No further adjournment.
No, my lord.
Is addressed.
13th of February, if my lord will kindly have it.
Not another. Convenient date kodtara. Yes, next.
I'm grateful, my lord.
List 1, serial number 3, praying for a short accommodation, your lordship. Respondent counsel has been informed.
Counsel for the petitioner.
Serial number 3.
For respondent, my lord.
Yes, you moved the memo.
Yes, yes, my lord.
Yes, you do.
Can you fix any date, my lord?
Yes, date will be given. Next.
Any date, my lord?
Date kodtare sir, tagolli. Next.
Serial number 8, madam. Serial number 8.
List 1,
Serial number 8.
urgent. List 1, serial number 1, Mohammed Pasha.
Appearing for the petition, your lordship.
Appearing
Lordship,
for the
I have got
respondent
a
number
NOC
2, my
wakalat. I'm filing a memo for withdrawal with a liberty. During the pendency of this petition, my lord, charges were framed. So we have filed a fresh petition with a consolidated relief. So filing a NOC wakalat along with the memo of withdrawal with a liberty to prosecute that matter, my lord.
What is your name?
Mashkur Hashmi, my lord, MD.
Have you filed wakalat?
I have just handed over, my lord. NOC I have got it, my lord.
Or tagolli so and so. Filed wakalat with the NOC from the earlier counsel. Office is directed.
And filed a memo also, my lord, with a liberty to prosecute WP 24477 of 2023.
Counsel for the petitioner filed a memo seeking the disposal of petitioner as not pressed. As withdrawn. Memo is placed on record, petition is dismissed as same is withdrawn. No, no, no. Yes, next.
Highly applied.
Next.
For respondent state, my lords.
ಪಾರ್ಟಿನ್ ಪರ್ಸನ್ HM ಜಯಣ್ಣ ಅಡ್ವೊಕೇಟ್ ಇಸ್ ಬಾಂಬೆಗೆ ಹೋಗಿದ್ದಾರೆ ಲೇಟ್ ಮೆಸೇಜ್ ಬಂದು.
My lords, this is the matter of 2016, my lords. Only small question of law is involved, my lords, where a magistrate has directed the concerned IO to hand over the investigation to CID, my lords, which is not permissible under law. I would like to rely upon the judgments of Honorable Apex Court, my lords.
ಮೇಡಮ್ ಮೇನ್ ಇದೆ ಅಂದ್ರೆ ಇದು ಸದಾಶಿವನಗರ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಕ್ಯಾಂಪೌನ್ಸ್ ಅಲ್ಲಿ ರಮೇಶ್ ರಾಮಯ್ಯ ಆಸ್ಪತ್ರೆ ಇದೆ. ಅಲ್ಲಿ HIV ಬ್ಲಡ್ ಟ್ರಾನ್ಸ್ಫ್ಯೂಷನ್ ಮಾಡಿದ್ದಾರೆ. HIV ಬ್ಲಡ್ ಟ್ರಾನ್ಸ್ಫ್ಯೂಷನ್ ಮಾಡಿದ್ದಾರೆ ನಮ್ಮ ಸಿಸ್ಟರ್ಗೆ. ಆಗ ಎಲ್ಲ ಈ ಡಾಕ್ಯುಮೆಂಟ್ ಆಸ್ಪತ್ರೆಯವರು ಡಾಕ್ಯುಮೆಂಟ್ ಫೋರ್ಜರಿ ಮಾಡಿದ್ದಾರೆ.
ಅಡ್ವೊಕೇಟ್ ಬರಲ್ವಾ?
ಅಡ್ವೊಕೇಟ್ ಮೇಡಮ್ ಇದು ಬಾಂಬೆಗೆ ಹೋಗಿದ್ದಾರೆ, ಲೇಟ್ ಮೆಸೇಜ್ ಬಂತು, 1 month ಟೈಮ್ ಕೊಡಿ. ಬಟ್ ಬ್ಲಡ್ ಇಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಬ್ಲಡ್
In person, my lords, as the party in person was not able to understand the legal consequences. Thereby, this honorable court has directed to engage a counsel. Thereby, a counsel was engaged.
Counsel is not appearing.
My lords.
Even the counsel is not appearing.
My lords, as the matter is pending, my lords, and the connected matter is WP, my lords.
Ask him to appear through VC. I'll pass
It may
over.
be passed on.
Pass over.
Serial number 3, urgent. 4, Hari Prasad MB. Kempraju.
Appearing for the respondent, my lord.
Who moved the memo?
They have moved the memo, my lord. I have not. It is a matter when, my lord, when 125 of maintenance is challenged. Court has ordered 2,000 rupees for wife, 1,000 for the child, my lord.
Whether that is being paid?
That is not paid. Memo of calculation is there. From past 12 years, they have not paid money.
Petitioner is absent, no representation. It is noticed that the petitioner has moved the memo for listing. In spite of that, there is no representation.
Memo of
Counsel for
calculation, my lord.
respondent number 2. Respondent number 1 filed the memo of calculation. He submits that the maintenance amount is not being paid regularly, and there is a balance of rupees 4,92,000 as on today. The memo is placed on record. Is there any stay? No.
There is no stay, my lord.
No. Counsel for the petition. Petitioner shall deposit cost of rupees 3,000 with and so and so for being absent even after moving the memo within 7 days. List on short date code. Next.
Number 5, urgent. 6, GS Balagangadhar.
Appearing for respondent number 2, my lord.
Please.
Yes, what is this?
My lord, in this case, my lord, the respondent number 2 has taken time to file objections. They have not filed any. Please,
Go ahead.
please.
Who moved the memo?
They moved
I
the
have
memo.
moved the memo, my lord.
Go ahead.
Please.
Who is the petitioner?
My lord, there are two matters, my lord. Petitioners are, my lord, accused in CC, my lord, 9564 of 2019. Accused number 23,
CC number 9564 of
2019, my lord.
19.
Please. My lord,
What are the offense?
my lord, offense is, my lord, 420, 468, 471, read with 34. My lord, the factual matrix is this, my lord.
1 minute. The
Please.
petitioner in 3043 is accused number?
3043 is accused number 2, 3 and 7, my lord. In another matter, my lord, accused number 13 and 14, my lord.
13 and 14.
14, another matter. Both are same, arising out of same CC.
In all, how many accused are there?
My lord, there are about
16 accused.
16.
What is the stage before the trial court?
There is
My lord,
stay,
now
my
it
lord.
is stayed, my lord. Stayed. Now my lord, my factual matrix may
Charge is not yet framed.
not it. My lord, it is what has happened, my lord, a complaint is filed by the second respondent. The police, my lord, submitted a B summary report. Then the second respondent complaint files a bald protest memo. Sworn statement is recorded. My lord, contrary to the procedure, my lord, the learned magistrate has taken cognizance, as against which, my lord, I am before your lordship. And my lord, interim stay is granted. They took time, my lord, to file objections. My prayer is, my lord, the entire orders passed by the learned magistrate is not proper and correct. Your lordship may kindly appreciate the locus standi of the complainant herein may kindly be perused. The impugned order is at annexure A, my lord. And my lord, that's there. Your lordship may kindly appreciate the complaint, the point number 1, my lord. They say that, my lord, about forgerying the signatures of 73 students.
Page number.
Page number 78, my lord, of the first matter. The allegations is that, my lord, we being the trust members and, my lord, at the relevant point of time, officers of the institution, we forged the signatures and, my lord, collected rupees 15,000 something from the management area. Then, my lord, it was taken up and then, my lord, no explanation is given. My prayer is, my lord, the locus standi of the complaint may kindly be perused. The learned magistrate comes to a conclusion, my lord, in the same line, third line, my lord. Hence, the fifth line. Hence, the complainant is one of the victim of the said anonymity, filed a complaint. My lord, neither he is the student, nor he has received any amount, nor, my lord, checks are bounced, nor, my lord, there is forgery. Now, my lord, the protest petition, for a moment, my lord, my prayer is protest petition which is shorn of all the details, my lord, contrary to section 2D of the earlier CRPC. It is at, my lord.
What is this KRLNM?
My lord, that is the.
This is rupees 15,000 per student.
They say that. That is what. And my lord, your lordship may kindly appreciate the complaint runs into pages. Annexure B, my lord. Annexure B starts from 83. And this is about, my lord, starts from page 83 to 87, 88, and, my lord, 91 and 92. This is the complainant he has filed. 2 persons. 92 may kindly be perused. Page. Then, my lord, the B report is at annexure C, 93.
What is the reason given by the magistrate?
My lord?
You are referring to page number 78.
Please.
What is the reason given by the learned magistrate?
Magistrate says that, my lord, he is the one of the victim. And, my lord, the statement of, I will read, my lord. The issued and got management quota of several engineer and medical colleges and got dropped out the said students and in their place. They allotted seats and other students by collecting huge amount and thereby cheated the government and also other students. Hence, the complainant is one of the victim of the said anonymity, filed complaint before the jurisdictional police, but the investigation officer has filed B report. In order to establish the prove the said facts, statements of the complaint is recorded as PW1 and produce 11 documents before the court in support of his oral contention. Now, my lord, protest petition for a moment, my humble submission may kindly be perused. This is what, my lord, I bring it to your lordship's kind consideration. Considered earlier, 106, my lord, annexure E. The complaint, my lord, runs into 8 to 10 pages. None of the complaint arguments are reiterated. Kindly peruse, my lord, 106, annexure E.
106 is the
Annex
protest memo.
protest memo. My lord, kindly peruse, my lord. The procedural aspect, my humble submission is, time and again, this honorable court has held that, my lord, protest petition should be in the nature of the complaint. Nothing is there. The first one, my lord, complainant Shivling Swami submits as follows. Complainant Shivling Swami has lodged a complaint before the DJLD police station against accused for the offences and later was referred to CCB police for investigation and to submit their report, and on the basis of the same, CCB police took up investigation. Then para number 2 is no proper investigation is done. Para 3 is, my lord, vaguely filed the B report without giving any opportunity. Then, my lord, kindly peruse next page, my lord, 107. The complainant has got very good case on merits and he is challenging the B report. This is all, my lord. My prayer is, my lord, when the complaint is there, as held by this honorable court,
B report.
my lord, B report is at, my lord, annexure C, my lord, starts from 93. And the final, the entire B report, my lord, investigation is done. And my lord, the students were inquired, but they were not available. And my lord, page, it starts from, my lord, overall the relevant witnesses are done.
No, where is the B report?
My lord, B report starts at page number annexure D 98, my lord. Page 90. Annexure C is FIR. My lord, annexure D is the B report. Lengthy B report. Every investigation. No, my lord, the complaint was filed for different offences. Neither 420 nor 468 is forthcoming. The person whose signature is forged, alleged to be, he is not a complainant. Here, my lord. In page 100, my lord, all the documents, my lord, GBN ಲಾಸ್ಟ್ ಅಲ್ಲಿ ತಾವು ನೋಡಬಹುದು. ಪ್ರಕರಣದ ಕಡತವನ್ನು ಹಿಂದಿನ ತನಿಖಾಧಿಕಾರಿಯಾದ ಶ್ರೀನಿವಾಸ್ PI ರವರಿಂದ ಪಡೆದು ತನಿಖೆಯನ್ನು ಮುಂದುವರಿಸಿದ್ದು 2011-12ನೇ ಸಾಲಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಕೆಳಕಂಡ ಅಂಶಗಳ ಬಗ್ಗೆ ತನಿಖೆ ಕೈಗೊಳ್ಳಲಾಗಿರುತ್ತದೆ. ಕಾರ್ಯದರ್ಶಿಗಳು ದಾಖಲಾತಿ ನೀಡುವಂತೆ ಸಲ್ಲಿಸಿದ ಕೋರಿಕೆ ಪತ್ರ, ಮಹದೇವ ಸ್ವಾಮಿ ಶಿವಲಿಂಗ ಸ್ವಾಮಿ ಅವರಿಗೆ ಸೂಚನಾ ಪತ್ರ. ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಮೇ ಕೈಂಡ್ಲಿ ಅಪ್ರಿಶಿಯೇಟ್ ದೇರ್ ಪ್ಲೀಸ್. ಅವ್ರನ್ನ ಎನ್ಕ್ವೈರಿ ಮಾಡಿಲ್ಲ ಅಂತಾನೆ ಮಾಡಿದ್ದಾರೆ. Detail, my lord, from 101, 101. There is also, my lord, the recording of the statements.
Yes.
Now, my lord, These statements and further, my lord, the final conclusion may kindly be perused. Entire investigation is page number 103, my lord.
Yes, I have gone through.
Please. And last one, your lordship may kindly appreciate.
105 I have gone through.
Yes. 105. My lord, my prayer is, if this is the situation, the protest petition, my lord, as held by this honorable court in several judgments, my lord, is not the reiteration of, my lord, complaint. And my lord, on the basis of the same, my lord, the learned magistrate takes a cognizance. Now, my lord, he is not the victim. Locus standi of the complaint, I am praying the honorable court to consider. If it is forgery, my lord, the person whose signature is forged, he has to be file a complaint. He is the aggrieved person. That is not done. And one more point, my lord, very important is, and the sworn statement may kindly be perused. Sworn statement, my lord, is absolutely contrary to, my lord, the protest petition.
Page number.
Please. My lord, page annexure F, my lord.
Page number.
Yeah, page 108, my lord. Idralli, what is stated in the complaint, your lordship may kindly appreciate, the gist of the complaint is this, my lord. There are several persons dropped out in the comment K, and my lord, in the comment K, the amount was collected, then it was surrendered, then that amount was taken, and the checks were taken out. And there is a forgery of the signature. Now, my lord, amount is given, and forgery, my lord, the students who surrenders the seats, they will be given the amount. They have to say that, my lord, our signature is forged.
Amount was seized from?
My lord, that was, he says that, my lord, 2011, 12 and 2012, 13. It was at 84, my lord.
From whom the amount was seized?
They say that, my lord, the dropout ಆಗಿದ್ದ ವಿದ್ಯಾರ್ಥಿಗಳು ಪಾಂಶುಪಾಲರಿಂದ ಹಿಂದಕ್ಕೆ ಪಡೆಯದೇ ಇದ್ದ ಹಣವನ್ನು ಓಪನ್ ಚೆಕ್ಗಳ ಮೂಲಕ ವಿದ್ಯಾರ್ಥಿಗಳ ಫೋರ್ಜರಿ ಸಹಿ ಮಾಡಿ ಪ್ರಾಂಶುಪಾಲರು ಪಡೆದಿರುತ್ತಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ. ವಿದ್ಯಾರ್ಥಿಗಳದ್ದು ಡ್ರಾಪ್ಔಟ್ ಆಗಿರ್ತಕ್ಕಂಥದ್ದು, ದಿ ಕ್ವಶನ್ ಈಸ್, ಇಫ್ ದಟ್ ಸ್ಟೂಡೆಂಟ್ ಈಸ್ ದೇರ್, ಮೈ ಲಾರ್ಡ್, ಇನ್ ದ ಬಿ ರಿಪೋರ್ಟ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಮೇ ಕೈಂಡ್ಲಿ ಅಪ್ರಿಶಿಯೇಟ್, none of the students have come forward and made an allegation. This is where, my lord, the magistrate has committed an error. Now, my lord, the documents they have produced, my lord, in the along with the sworn statement, my lord, I have not produced that. Now, even otherwise, nowhere, my lord, he says that, my lord, it was withdrawn or utilized. The statements are on different footings. ಅಂಡ್ ಪೂರ್ವಯೋಜಿತ ಇದರಲ್ಲಿ 84ರಲ್ಲೇ ಪೂರ್ವಯೋಜಿತ ಪಿತೂರಿ ಮಾಡಿ ಓಪನ್ ಚೆಕ್ಗಳಿಗೆ ವಿದ್ಯಾರ್ಥಿಗಳ ಫೋರ್ಜರಿ ಮಾಡಿ ದುರುಪಯೋಗ ಪಡಿಸಿಕೊಂಡಿರುತ್ತಾರೆ. ಈ ರೀತಿ ಮಾಡಿದ್ದಾರೆ ಅಂತಂದ್ರೆ, ಮೈ ಸಬ್ಮಿಷನ್ ಈಸ್, ಮೈ ಲಾರ್ಡ್, ದೇರ್ ಮಸ್ಟ್ ಬಿ ಅನ್ ಅಲಿಗೇಷನ್ ಬೈ ದ ಸ್ಟೂಡೆಂಟ್ಸ್. ನೋ ಸಚ್ ಅಲಿಗೇಷನ್ ಈಸ್ ದೇರ್. ಬಿ ರಿಪೋರ್ಟ್, ಮೈ ಲಾರ್ಡ್, ಕೈಂಡ್ಲಿ peruse, my lord, the
please, my lord. My lord, the case of the prosecution is that, my lord, that the members of the Ambedkar.
One more submission, with the permission. My lord, so far as this person is concerned, complainant, he was working with us. My lord, kindly peruse, my lord, annexure. The order copy I have produced, he has been dismissed. Annexure G, my lord, 115. He worked as a, my lord, physical education instructor. Kindly appreciate, my lord, he was absent. He was clear. He was alleged for indiscipline and misconduct. My lord, he was removed from the service after due inquiry. This is very important point for the consideration. This is starts at 115, my lord. Ado, he was dismissed 2002. 2007, my lord. Proceedings were taken up. 2007, he was dismissed. Now, my lord, he challenges the same in MA EAT before the learned appellate tribunal, education appellate tribunal at annexure H. In annexure H, your lordship may kindly appreciate, he was only given, my lord, order page number 136 and 137, my lord. Here, issue number 3, 136 is very important. The conduct is not eschewed. My lord, may I read issue number 3, finding, my lord, page 136 at annexure H.
It was ordered to be reinstated.
Reinstated, but my lord, kindly appreciate, he was not given without consequential benefits. My lord, para 15, my lord, may kindly be
So he
produced.
was reinstated.
Reinstated, but issue number para 15,
He is still working.
no, he has retired. According to me, he has retired.
He is retired.
Retired. He was given all the benefits, he has retired. I mean, retirement benefits, not these benefits.
When he retired?
But that I have to get the information.
When he retired?
Last year, my lord,
25.
25.
When the complaint was filed?
May I go on, my lord?
My lord, complaint-
22/8. May I make my submissions, my lord?
Complaint dated?
22/8/2014.
18/8/2014, my lord.
B report is on 31/2016.
No, complaint dated 22/8.
No, no, my lord, 18/8/2014, annexure B.
FIR is registered on 22/8/2014, my lord. Crime is registered on 22/8/2014. B report is filed on 31/2016. Protest memo is filed on 29/11/2016. The court, my lord, on protest memo takes cognizance on 8/3/2019. Evidence of the PW1, that is respondent number 2, respondent is recorded on 7/12/2020.
Whose evidence?
My evidence, my lord. PW1, complainant's evidence. It's
recorded.
recorded, my lord. I will take my lordship.
1 minute.
7/12/2020, my evidence is recorded in part. And 7/12/2020. A 91 application is filed before court, my lord, calling for checks, my lord, on 12/8/2021. The same 91 application is allowed on 17/1/2022. I'll take my lordship to facts, my lord. My lord, facts, brief facts of the
My lord,
case is
one-
that,
one
my lord.
submission, my lord. I have not yet completed. I want to bring it to some more points for the kind consideration. Later you can. My lord, 136 may kindly be perused. Very
Sir,
important.
you are challenging the order taking cognizance.
Yes,
That was in the month of March 2019.
please.
Why you filed this petition in 22?
My lord, what has happened? Section 91 petition was challenged earlier. That was withdrawn.
This order was not challenged immediately.
Yeah, my lord, that was, my lord, that was
Why it
later.
is after 3 years?
My lord, we received the summons later. We appeared.
That cannot be the ground.
No, no.
That cannot be
No,
the
my
ground.
lord.
By the time, according to her, the
No,
evidence
no,
of the
my lord, there
witnesses-
was corona also. We could not get the ಒಂದು ಎರಡು ವರ್ಷ ಅದು ತಮ್ಗೆ ಗೊತ್ತೇ ಇದೆ.
19 ನಲ್ಲಿ there was no corona. Please.
ಅಲ್ಲಲ್ಲ 19 ಅಲ್ಲಲ್ಲ ನಮ್ಗೆ ಸಮನ್ಸ್ ಬಂದಿದ್ದೆ ಲೇಟ್ ಆಗಿ
2019.
ತಾವ್ ನೋಡ್ಬೋದು. ಅಲ್ಲ ಸುಮ್ ಒಂದ್ ನಿಮಿಷ 4/12/8/3/19 ನಲ್ಲಿ ಒಂದ್ ನಿಮಿಷ
ಕೊರೋನಾ ಎಲ್ಲಿತ್ತು?
ಅಲ್ಲ 19 ಆದ್ಮೇಲೆ ನಮ್ಗೆ ಆರ್ಡರ್ಸ್ ಬಂದಿದ್ದು 22/6/19 ನಲ್ಲಿ ಒಬ್ಬೊಬ್ರಾಗ ಅಪಿಯರ್ ಆಗಿದ್ದು.
ಅವಾಗ್ಲೂ ಕೊರೋನಾ ಇರ್ಲಿಲ್ಲ.
ಅವಾಗಿರ್ಲಿಲ್ಲ. ಆಮೇಲೆ ಬೇಲ್ ತಗೊಂಡಿದ್ದು 2/7/19 ನಲ್ಲಿ. ಆಮೇಲೆ ಮೈ ಲಾರ್ಡ್ ಬಿ ಅಪಿಯರ್.
Don't blame corona for anything.
No, my lord. Because of that fact, I brought it to your lordship. My lord, that may not be, my lord, may not be fatal to my case. My prayer is this: your lordship may kindly appreciate the protest memo, everything, my lord. It is not in accordance with the today. ಅಲ್ಲಲ್ಲ ಅದನ್ನ ತಾವು ಕನ್ಸಿಡರ್ ಮಾಡದೆ ಹೋದ್ರೆ ಅರ್ಲಿಯರ್ ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ತಮ್ಮ ಗಮನಕ್ಕೆ ತರ್ತೀನಿ. ಕೊಡ್ತೀನಿ. ಆಮೇಲೆ
You summarize your
ಪ್ಲೀಸ್
intentions.
ಮೈ ಲಾರ್ಡ್, ಫಸ್ಟ್ ಮೈ ಲಾರ್ಡ್ ಕೊಡ್ತೀನಿ. First, my lord, kindly peruse, my lord, para 15, my lord. That is most important. Page number 136. Though reinstatement is ordered, the findings on above issues do not mean that this appellant is free from blemish. For this, I would straight away refer to his cross-examination. Page 13, he admitted that there was strike for 6 months in the hospital and college, and he, being the president of Employees Association, participated in the strike during that period. This is really ridiculous that just because he is the president of the association, appellant cannot be expected to take the law into his own hands. Page 136, my lord. The another serious allegation that this appellant threatened the co-employees in attending the duty and forced them to join the strike with him shows that again is the ethics and moral obligation of providing treatment to the patients. This appellant and others caused hurdles in the smooth functioning in the hospital as well as college. This makes this tribunal more cautious in granting reliefs to him. The tribunal has to understand the concern of the Honorable Supreme Court against such illegal strikes and boycotts which are eating away the development of our nation and causing damage. To cite one such example, I refer to the decision in Harish Uppal versus Union of India. Therefore, holding that it was incorrect on the part of the appellant in striking the work for 6 months, he does not deserve any sympathy. Nevertheless, charges are not proved. I hold that at the most, tribunal can reinstate him to the duty without the consequential benefits, as he did not serve the institution during the said period. Therefore, my lord, appeal was partly allowed, ordered to be reinstated. Now, my prayer is this, my lord. The conduct of this person may kindly be perused. And my lord, I have also produced the notification, that is change of office bearers of Ananda Social and Educational Trust, page number 140, 31/3/2021. There, my lord, the management entire has been changed. And now, my lord, he charges them, my lord, they are in charge of the same and they have done it. The B report clearly reveals that. Now, my lord, in the second matter, your lordship may kindly appreciate, the allegation is against the accused numbers in the same matter. Accused number 13 and 14. He says that, my lord, they were the professor and my lord typist. My lord, they were not at all concerned with all these aspects with regard to surrender of the seats or other aspects. They're adding in the proceedings, my lord, it is abuse of process of court. There is no, my lord, your lordship may kindly appreciate entire reading of the complaint. My lord, it reveals that, my lord, none of them are concerned with these aspects. Now, my lord, they say one PL Nanjundaswamy was chairman at the time. Now, my lord, 114, that's why I submitted. The statement, sworn statement is contrary to the complaint governments. This is where, my lord, the learned magistrate committed, and they were not charged. Now, my lord, the judgments which I want to bring it to your lordship's consideration is, my lord, the very first judgment is ILR 87, Karnataka 997. Because, my lord, two things may kindly be considered.
Why you are relying on this?
Yes. One is that, my lord, it was not a private complaint. It was filed to the police.
Which is the paragraph?
Please. My lord, page 994. Kindly, my lord. Head note B.
Head note ಬೇಡ sir.
ಅಲ್ಲ ಇದು
Orders ನಲ್ಲಿ
Orders ನಲ್ಲಿ the B summary report and, my lord, it is at, my lord, page 996. Magistrate refers the complaint to the police under section 156, and on investigation, police submit B summary report. Complainant protest to the acceptance of the B summary report. In such cases, magistrate may take cognizance on the original complaint made to him. Records sworn statement under section 200 CRPC. If there is no complaint made to the magistrate, question of magistrate taking cognizance on the basis of the protest memo does not arise, particularly when the protest memo is not in the form of a complaint and there are no allegations constituting any offense in the protest memo filed, and there is also no request to take action. Page 997. 997. So, ಇದು ಇಂಕ್ ಪೇಜ್ 4. ನಾನು ಅದಕ್ಕೆ ನಾನು ಇಲ್ಲೇ ಫಸ್ಟ್ ಅಲ್ಲಿ ಹೇಳ್ಬಿಟ್ಟೆ, ಪ್ಯಾರಾ 4 ತಾವು ನೋಡ್ಬೋದು ಅಂತ. ಕೊಡ್ತಾ ಇದ್ದೀನಿ, ಓದ್ತಾ ಇದ್ದೀನಿ. ಪ್ಯಾರಾ 4 ಅಲ್ಲಿ ತಾವು ನೋಡ್ಬೋದು. It starts from 996, ink page number 3. My lord, where there is a complaint made to the magistrate and the magistrate refers the complaint to the police under section 156, and on investigation, police submit B summary report. Complainant protests to the acceptance of B summary report. In such cases, magistrate may take cognizance on the original complaint made to him. Records sworn statement under section 200 CRPC. This is not the case here. Second, my lord, if there is no complaint made to the magistrate, question of magistrate taking cognizance on the basis of the protest memo does not arise, particularly when the protest memo is not in the form of a complaint and there are no allegations constituting any offense in the protest memo. There is also no request to take action. Now, my lord, protest memo I have brought it to your lordship's notice. Therefore, my lord, it was not a complaint. There are no such allegations in the protest memo. Therefore, it was not a complaint within the meaning of that expression as defined under section 2D. Therefore, my lord, the petition is allowed, impugned order passed by last line, my lord, passed by the sessions judge, set aside, order passed by the magistrate, accepting the B summary report is restored. B summary report was accepted. Now, my lord, it was by the police, an authority. Inquiry has been done. Students have been, they were not available. And now, my lord, second judgment, my lord, ILR 2018, Karnataka 1725. This is also very important, my lord. The options, that is, which is to be followed by the courts, my lord, by the trial courts. The His Lordship Justice Panindra has considered at length. My lord, the challenge to the head note, acceptance or rejection of B summary.
ಹೆಡ್ ನೋಟ್ ಓದೋದು ಪ್ರಾಕ್ಟೀಸ್ ಬಿಟ್ಬಿಡಿ.
ಬಿಟ್ಬಿಡ್ತೀನಿ ಸರ್.
ಜಡ್ಜ್ಮೆಂಟ್ ನಲ್ಲಿ ಪಾರ ಯಾವ್ದಿದೆ ಅಂತ ಹೇಳಿ.
ಅದನ್ನೇ ನಾನು ಓದ್ತಾ ಇದ್ದೀನಿ. ಸರಿ, ಪ್ಯಾರಾ 5-7. The procedure followed, page 12 ತಾವು ನೋಡ್ಬೋದು. Procedure followed by the learned magistrate is not in accordance with law. It is well recognized principle of law that once the police submit B summary report, protest petition is filed, irrespective of contents of the protest petition, court has to examine the contents of B summary report so as to ascertain whether the police have done investigation in a proper manner or not. And if the court is of the opinion that the investigation has not been conducted properly, court has got some options to be followed. Court, after going through the contents of investigation papers filed under section 173 of CRPC, is of the opinion that investigation has not been done properly. The court has no jurisdiction to direct the police to file the charge sheet. Court may direct the police for or further investigation and submit a report, which power is inherent under section 156. Then, my lord, 2. If court is of the opinion that the material available in the B summary report makes out a cognizable case against the accused and the same is sufficient unto issue process, then the court has to record its opinion under 204 of CRPC. Court has got power to take cognizance on the contents, proceed against. Third, if the court is of the opinion that B summary report by the police has to be rejected, then by expressing its judicious opinion, after applying its mind to the contents of B report, court has to reject the B summary report. After rejection of the B summary report, the court has to look into private complaint or protest petition as the case may be, and contents therein to ascertain whether allegations made in the private complaint or in the protest petition constitute any cognizable offense. No, my lord, private complaint is out of picture. Protest petition is not there. And my lord, the orders I have already brought it to your lordship's notice, consideration that nothing is discussed. Then, these are all the, my lord, the detailed procedures, my lord, have been directed. Then, my lord, ILR 2002 also, my lord, page number 19. His Lordship Karnataka 1665. My lord, I will read para number 9, my lord. That is the head note. I will read. Earlier considering all. The position from the above, 26 page thavu, 1672 nodಬೋದು. From the above, position that emerges is this, where initially the complainant has not filed any complaint before the magistrate under section 200 CRPC, but has approached the police only, and where the police after investigation have filed the B report. If the complainant wants to protest, he is thereby inviting the magistrate to take cognizance under section 190 subclass 1A of CRPC on a complaint. If it were to be so, protest petition that he files shall have to satisfy the requirements of a complaint as defined in section 2D CRPC, and that should contain facts that constitute offense for which learned magistrate is taking cognizance under section 191A CRPC. Instead, if it is to be simply styled as a protest petition without containing all those necessary particulars that a normal complaint has to contain, then it cannot be considered as a complaint for the purpose of proceeding under section 200 CRPC. That is what has happened in the present case, and in my opinion, contests of protest petition do not make document concerned a complaint. This is exactly my case. Yes. Now, my lord, next judgment, my lord. This is, my lord, the Bhajanlal's case, my lord, which, my lord, already considered in a majority of the matters. This is considered, and my lord, one more judgment, my lord, the Honorable Supreme Court, that, my lord, I will furnish. Yes, My lord, 2019 Supreme Court 3482. My lord, I could not present it, sir. That I will submit. That kodappa ಅವ್ರಿಗೊಂದು copy ಕೊಡಿ. 3482. My lord, squarely on that point. Honorable Supreme Court.
What point?
Here also the similar situation. My lord, head note is to that effect. Anyhow, my lord, I will read the relevant para as your lordship directed. 31, 33, 41, 45. Yes, I will. That was under 304B. My lord, 44, para number 44 may kindly be perused. Complaint is defined in section 2D of the code. Complaint means so and so.
It's made clear, the position of law is very well.
Yes. If, my lord, 45, my lord, para 45, if a protest petition fulfills the requirements of a complaint, magistrate may treat the protest petition as a complaint and deal with the same as required under section 200. Read with section 202 of the code. In this case, in fact, there is no list of witnesses as such in the protest petition. My lord, the protest petition, I have brought it to your lordship's notice.
Yes.
The prayer in the protest petition is to set aside the final report and to allow the application against the final report. While we are not suggesting that the forum must entirely be decisive of the question, whether it amounts to a complaint or liable to be treated as a complaint, we would think that essentially the protest petition in this case is summing up of the objections. The second respondent again is the final report. This brings us to one aspect of the matter which in fact was not argued. The appeal is filed by the others, that may not be necessary. So 45, my lord, clarifies this situation. Now, my prayer is, my lord, if private complaint was there, magistrate acted under 156(3), the B report was filed, then, my lord, situation would have been different. And the entire investigation is done. Now, my lord, it is under the 482, my prayer is absolute abuse of process of court because of the reason that there was no allegations, they have no locus standi, and at the same time, my lord, nothing on record to show that they are concerned with these, what are all the allegations made against them. And my lord, even my lord, in that judgment also, my lord, I have produced two more judgments. That is, one is first one 398 of criminal petition 398 of 2013, my lord. I have not paginated, I am sorry, my lord. Two sets I have filed. 87 years I already produced. Criminal petition number 398. His lordship considered on the similar situation. Considering all these aspects, 87 Basappa's case which is followed, my lord, page 10 of the same. Criminal petition allowed is quashed. Entire proceedings. That was under the special case. Similar to that. Atrocities Act case. That was quashed. Then, my lord, already I have produced 2018. Another, my lord, the criminal petition number 6783 of 15.
Sir, you may cite hundreds of such cases.
Please.
Now the position of law is very well settled.
That is the law.
It is not advisable to cite all the decisions.
Yes.
You may find 100, 500, thousands of such cases.
Please. That's what I brought
Yes.
it to.
May I make my submission, my lord? My lord, the facts of the case.
The position of law is very well
I'll just
settled.
take my lordship to one application, my lord. They've suppressed certain facts before my lordship. Now I'll make submissions, my lord. My lord, case of the prosecution is that 73 dropout students, my lord, the accused, my lord, are members of Dr. Ambedkar Medical College. They have, my lord, misused the checks belonging to 73 medical students, and for the tune of 51 crores, my lord, they've allotted the same medical, my lord, seats to management trustee grandchildren, children, my lord. That is the case of the prosecution. While filing B report, my lord, CCB does not inquire any of the students, nor, my lord, they ask for the check. I, my lord, go to the court, I file a B report, same is agreed, accepted, cognizance is taken, I produce certain documents.
That was in accordance.
Please, my lord, I've produced certain documents. Meanwhile, after recording of my evidence, my lord, I filed for a 91 application.
Asking you a question, you are supposed to answer.
Please.
ನೀವು ಇಲ್ಲಿ record ಮಾಡ್ಕೊಂಡು ಬಂದು ಇಲ್ಲಿ
ಇಲ್ಲ.
ಹೇಳಿದ್ರೆ ಅಲ್ಲ.
They have not
You should
produced.
Answer the question.
Please, my lord.
And you should convince the court.
Please, my lord.
Then only
please.
I will proceed. Otherwise,
Please.
no.
Please.
I am asking you.
Please, my lord.
Yes, you filed the protest memo.
Please.
Whether it is in the form of protest petition as required under law. Because it is not a private complaint.
Please.
It is the police complaint.
Please.
So there must be a complaint.
Please, my lord.
As per the decisions of the apex court as well as this court.
Please, my
Now
lord.
the position of law is very well settled.
Please.
In the light of those decisions,
Please, my lord.
your protest memo can be taken into consideration. And secondly, it is the settled position of law.
Please, my lord.
Before the learned magistrate proceeding to accept the protest memo and taking cognizance,
Please, my lord.
he has to verify the B report filed by the investigating officer. And he has to either accept the B report or he should reject the B report by assigning reasons.
Please, my lord.
That is not followed by the learned magistrate.
Please, my lord.
Yes.
Please, my lord. While, my lord, the honorable magistrate considering the B report, my lord, has, my lord, looked into the documents that I have produced. There are certain documents which I
Is
clearly.
there any order rejecting the B report, assigning any?
No, my lord, the order passed, my lord, what the CCB, my lord, says while filing B report, stating that, my lord, there were not sufficient materials forthcoming, hence, my lord, they say B report was filed. During my protest memo, I have produced certain documents to the court, my lord, to show that there were sufficient documents where the CCB.
Whether the procedure is followed, that is the question. You may produce hundreds of the
Please.
materials.
Please.
Whether the learned magistrate has passed for the procedure as contemplated under law.
Please.
Procedure in 200 complaint case is different from
Please.
the police complaint case.
Please. Madam, order pass agita to 200. Yes, my lord, the magistrate has, we have filed the application as per the law, my lord.
Which application?
The protest memo application.
Protest memo, do not satisfy the requirement of the complaint under section 200.
Please, my lord, for a moment,
You
if I
look
may.
at the protest memo, whether it will satisfy the requirement of a complaint under section 200.
Order on B report.
That is the requirement of law.
Please, my lord, merely, my lord, on an error of such application, my lord, there is only one.
Very serious, it will go to the
Please.
root of the matter.
Please, my lord, please. I will answer to that, my lord. For the same question, my lordship may permit me, I'll answer to that. Meanwhile, there's only one document that I want to show to my lordship where, my lord, they earlier filed an application before the coordinate bench of this honorable court. For a moment, if my lordship looks at this
How many
application.
witnesses you want to examine?
My lord, for a moment, this application, if my lordship looks at. Please,
Who
my
are
lord.
the witnesses you are going to examine before the trial court?
My lord, witnesses, my lord, are the members of members of the Ambedkar College, my lord. There are certain students, my lord, who have also.
The list of witnesses is already filed.
During my lord.
Because protest petition does not
Cite witnesses.
enclosed with a
Please.
list of witnesses.
It states only PW1 has the present
Then
petition.
is it
respondent.
sufficient the evidence of PW1? The legal requirement as initiated in 18 of decisions are never followed.
Please.
Unfortunately.
My lord, during the
You may
course.
call for records, you may send it for what is that handwriting expert, you may call for the expert, every step you can take. But what about the procedure? What is the procedure contemplated?
Reject ಮಾಡ್ಬೇಕಾದ್ರೆ full reasons ಹೇಳಿಲ್ಲ.
Okay.
At every stage, the procedure is not followed.
Please. One document. Just one document. I'll answer my lordship to the question my lordship has raised. I'll definitely take my lordship to it. Meanwhile, to show the court that they had earlier approached this court, when the court expressed the opinion as to not pass out orders, they withdraw the application, they filed another petition before the court. Other answer, my lord.
Full
Okay,
detail
that
ಆಗಿ
I'll
ಬೇಕು.
answer.
What
But
is this?
page number 6, my lord. A 91 application is filed by the complainant, that is on 12/8/2021. On 17/1/2021, same is allowed. May I take my lordship to page number 6?
No,
17/1.
when the accused appeared before the trial court,
My lord, the accused, my lord, appeared before the magistrate, my lord, on 17/12/2020.
When?
17/12/2020 was when his statement was recorded.
Whose statement?
Evidence of PW1, that's the complainant.
No, when the accused appeared before the learned magistrate.
Accused, my lord, have been appearing before the magistrate after cognizance, that is on 8/3/2019. Cognizance was taken on 8/3/2019. Subsequently, after taking of cognizance, accused, my lord, have appeared before the court and sought for bail
Do
and.
you have the date with you?
Yes, it's in order sheet. It's in order sheet. I'll take my lordship to page number 33 of the order sheet.
When the accused appeared before the.
Please. Page number, my lord, 30 in the, my lord, on 22/6/2019.
22/6.
2019.
When the charge was framed.
Charge, my lord, cognizance was taken on 8/3/2019.
Charge.
Charge is not framed. Charge, my lord, was framed on. My lord, charge, PW1 evidence is recorded. Charge, my lord, is not framed yet.
Without framing charge, PW1 was examined.
ಇಲ್ಲಿ order sheet ಅಲ್ಲಿ mention ಮಾಡಿದ್ದಾರೆ. Page number 38, my lord, is the order sheet. 39 is accused being present, them taking bail, my lord. Subsequently, my lord, in the year 2019, accused were present. And, my lord, in the view of COVID-19 closure of courts, accused presence, case called out. Then, my lord, directly, my lord, in the order sheet it says complainant is absent, counsel for so and so, accused 1 to 6 are absent, EP file, evidence of PW1 is recorded in part and chief before court. 46 ಅಲ್ಲಿ evidence of PW1 is recorded in part in chief before charge. Before charge, charge is not framed. 46. Evidence of PW1 is recorded in part.
On which date?
On 7/12/2020. For further chief examination of PW1, call on 30/12/2020.
So charge is not yet filed.
Please, not yet framed.
In the meantime, 91 application was filed.
Was filed on 12/8/2021. On 12/8/2021, 91 application is filed. Same is allowed on 17/1/2022. Page number 6 of the additional document which I have given to my lordship. Para number 7, my lord. 7. Point number 1. DJLE police have registered the case against accused person for the offence under section so and so on. The specific allegation that accused persons being members of management of Ambedkar Medical College have misappropriated funds to an extent of 2,60,75,500 for the year 2001 to 12 to 2013 to 14 belonging to 73 dropout students of Commit K. Page number 6, my lord, para number 7. It is further alleged that they have misused the above amount by forging signatures of students. Further, they received 51 crores from non-qualified students.
What is that you are reading?
My lord, the order on application 91.
That is allowed.
It is allowed.
It was challenged before this court.
The order was allowed. The court, my lord, calls for all the checks, wherein, my lord, where a tune of 51 crores was misused with check numbers, my lord. Page number 112 is the numbers.
Those checks, 73 checks were.
Please, all the checks were summoned from the bank. Subsequently, my lord, they file a 482 petition before the court.
About misappropriation.
Please, my lord.
Who will speak about misappropriation? How the misappropriation has taken place?
My lord, the students, my lord, whose checks have been misappropriated. Initially,
Are
my
you
lord,
going to examine those students?
we will, my lord, during the course
Have
of
you
trial.
filed the witness list?
My lord, immediately, my lord, they sought for a stay. From past 2.5 years, my lord, this case has been stayed. No opportunity was given to me. My lord, one submission, they filed, my lord, 482.
Whether the procedure as contemplated is followed in this case.
My lordship, first and the foremost thing, the protest petition is not completely explained, my lordship, in the order.
That is not in the form of a complaint.
Please, my lordship.
Under section 200.
Please, my lordship.
That is the first requirement.
Please, my lordship.
And thereafter the order taking cognizance was passed. There is no reference to the finding recorded by the investigating officer. The report was not rejected.
Rejecting and accepting the protest petition also, it is nothing is mentioned in the
Yes,
order.
only said sufficient materials are produced, I am satisfied. Where is the list of witnesses?
List of witnesses are also not being along with the protest petition, my lordship.
So the procedure as contemplated is not followed. I am not saying that there are no materials, but the procedure, there is a sufficient deviation from the procedure. It cannot be neglected altogether, ignored altogether, or rather.
It may be remanded back with the direction to the magistrate.
You file a regular protest petition, let the magistrate consider that in the light of the B report as required under law and proceed.
Obliged, my lord.
Here, that is why repeatedly I am asking whether charge
Please,
is
I'll
framed,
do
whether
that.
charge is framed. You are into the production of, what is that, filing of application. You are not concerned about that.
Please. My only submission was to show to the court that, my lord, when the court expressed the opinion as to not to allow application, they suppressed 91 in that petition. They've come to court after 3 years challenging cognizance, my lord. Now, my lord, as my lordship told, I will file an application, my lord,
At the
necessarily.
beginning, there is a
Please,
problem.
please.
The procedure is not followed
Please, my lord.
by the complainant as well as by the court.
Please.
So the order taking cognizance will have to be set aside. And the trial, the learned magistrate is required to follow the procedure as contemplated in the various decisions. Proceed with the matter.
Please.
You also required to file the protest petition as required under law.
Please, my lord.
Otherwise, there is no pleadings. There is no basis for the learned magistrate to proceed. On what basis he will frame charge? Tell me.
Please.
On your own statement, he will frame charge. On protest petition, he will frame charge. What is the basis?
Yes, my lord. We'll file necessary application
You
before the
should
trial
understand
court.
why I am intervening every now and then. I can understand your anxiety, but that cannot be the. You should understand why the question is being posed. Yes, I will allow the petition, set aside that order with the direction to the learned magistrate to follow the procedure.
Please.
ಇದು
Because
10 ನಿಮಿಷದಲ್ಲಿ ಆಗುವಂತದ್ದು. ಅವರು ಕೇಳಲಿಕ್ಕೆ ತಯಾರಿಲ್ಲ, ನೀವು ಕೇಳಲಿಕ್ಕೆ ತಯಾರಿಲ್ಲ.
ನನ್ನ ಕ್ಷಮಾಪಣೆ.
ಕೋರ್ಟಿಗೆ ಏನು ಗೊತ್ತೇ ಇಲ್ಲ. Argue hours together ಅಂತ ನಿಮ್ಮ ಭಾವನೆ.
My apologies.
You are very much agitated.
No.
The court interfere ಆಗಬೇಕು ಅಂತ. Without understanding the consequences.
My apologies. My apologies.
Sir, by all such things, you
Please.
can cut short your argument.
Please.
And save the precious time of the court.
Exactly. I will avoid.
Why I am interfering?
Yes.
Without understanding illa, judgment ಇದೆ, ಅದಿದೆ, ಇದೆ.
I abide by the directions from here afterwards. Please. One more submission with the leave. When that goes back to the magistrate, my lord, I may not have any say.
You
So
will not. You
I
will
will
not
not
have this.
Yes, and magistrate may kindly be directed as.
He will follow the procedure.
Please.
They need not have to
Please.
say
Please.
everything.
Please.
Good. Common order. The petitioners being accused number 2, 3 and 7 in the petitioners in criminal petition number 2043-22 being accused number 2, 3 and 7 and petitioners in criminal petition 3073 of 2022 being accused number 13 and 14 in CC number 9564 of 2019 pending on the file of the learned first additional chief metropolitan magistrate Bengaluru are seeking to quash the order dated 8/3/2019 taking cognizance of the offence punishable under section 420, 468, 471, read with section 34 of IPC. Third, affirmative for the following reasons. Respondent number 2 filed the first information with DJ Halli Police against accused. Initially, FIR is against how many accused? 6 against accused numbers 1 to 16. Alleging commission of the offence punishable under section 420, 468, 471, read with section 34 of IPC. The investigation was undertaken and the investigating officer filed the B report stating
that even after collecting the documents and recording the statements of the witnesses, he could not find sufficient materials for filing the final report for constituting the offence as stated above. Constituting the offence as alleged by the complainant. Pursuant to filing of the B report, the respondent number 2 informant was notified. He appeared before the trial court and filed the protest petition. The sole statement of respondent number 2 was also recorded by the learned magistrate. On the basis of the same, the order impugned dated 8/3/2019 was came to be passed, where the learned magistrate took cognizance of the offence for the above offences and summoned the accused by registering CC number so and so. The said order is called in question by the petitioners by filing the petitions. Next, learned counsel for the petitioner contends that the learned magistrate has not followed the procedure as required under law, and therefore the impugned order requires to be quashed. If we place reliance on the following decisions, ILR 2018 Karnataka 1775, wherein the coordinate bench of this court highlighted the procedure that is to be adopted by the learned magistrate in case of a complaint filed under section 200 and filing of the B report by the police on investigation, and also the procedure when the B report is filed by the investigating officer on a police complaint. The para 5 of the order reads as under the relevant portion of para 5 reads as under Roman small 5. In the present case, he has also placed reliance on the decision in Veerappa and others versus so and so, ILR 2002 Karnataka 1665, where the coordinate bench held in para 9 as under the council also placed reliance AR 2019 Supreme Court 3482, where the apex court held in para 45 as under the position of law regarding the procedure that is to be followed by the learned magistrate on filing of the B report by the investigating officer is very much settled. In case of a police complaint, if the investigating officer files a B report of an investigation, the complainant is required to be notified, upon which he can file the protest petition, which shall be in the form of a complaint required to be filed under section 200 CRPC. If such a protest petition is filed, the learned magistrate is required to follow the procedure as contemplated in the chapter 15 of CRPC. Record the sworn statement of the complainant. Consider the materials that are placed before the court in support of the allegations made against the accused. He is required to consider the B report submitted by the investigating officer. If he is not satisfied with the B report, the learned magistrate is required to reject the same by assigning reasons, and he can proceed to accept the protest petition in the form of a complaint for the purpose of taking cognizance if the materials that are placed on record are sufficient to do so. In the present case, even though the respondent number 2 had filed the police complaint, the investigation was undertaken and B report came to be filed, holding that there are no materials to substantiate the allegations made by the complainant. Even though the protest petition is filed by the complainant, the same is not in the form of a complaint required to be filed under section 200 CRPC, but it is only a memo filed by respondent number 2 stating that a complaint was filed with the DJ Halli police against the accused. The investigation is undertaken and B report is filed. The B report filed by the investigating officer do not have valid reasons for the conclusion arrived at. The complainant is having very good case on merits and hence prayed for rejection of the B report and permitting the complainant to prove his case. There are no other details or particulars, nor there is list of witnesses or list of documents which are relied on by the complainant. However, the learned magistrate proceeded to record the sworn statement of respondent number 2 and pass the order impugned, taking cognizance of the offence. Even in the impugned order, the learned magistrate never refers to the B report by the investigating officer, except stating that in view of the materials that are placed by the complainant, the B report submitted by the investigating officer is required to be rejected. It is pertinent to note that the complainant has not examined any witnesses on his behalf. It is stated that subsequently an application under section 91 of CRPC was filed seeking to summon various checks which are said to be forged by the accused, and those checks were already produced before the trial court. Mere summoning and production of the checks may not be sufficient trial court to frame charge against the accused. On the basis of the police complaint, the trial court cannot frame the charge because B report is filed by the investigating officer. No protest petition in the form of a complaint required to be filed under section 200 CRPC is filed to enable the trial court to frame the charge. On the basis of the sole statement of the complainant, the court cannot frame the charge. Therefore, even though I find that there is inordinate delay in the petitioners approaching this court seeking to set aside the order taking cognizance, I do not find any basis for the trial court to frame charge against the accused. There is no list of witnesses, no list of documents that are relied on by the complainant. Under such circumstances, the entire procedure adopted by the learned magistrate is vitiated and it is not in accordance with law. Therefore, I am compelled to set aside the order dated 8/3/2019 taking cognizance of the offence against the accused. The learned magistrate is required to permit respondent number 2 to file the protest petition in accordance with law. If such a protest petition is filed, he can proceed to consider the protest petition, the B report, and the other materials that may be produced by the complainant in accordance with law in the light of the directions, in the light of the decisions referred to above, and pass necessary orders. If after considering all these materials, the learned magistrate finds it necessary to take cognizance, he is at liberty to do so and register the criminal case for the purpose of summoning the accused. The learned magistrate is required to follow the procedure meticulously, since the allegations made by the complainant against the accused is of serious nature. Therefore, without going into the merits of the allegations, I deem it appropriate to set aside the order taking cognizance only on the ground that there is a procedural lapse in passing the said order dated 8/3/2019. Accordingly, I answer the above point in the affirmative and proceed to pass the following. Petitions are allowed, so and so fast. Learned magistrate is directed to, the registry is directed to communicate this order to the learned magistrate at the trial court. On receipt of the order, the learned magistrate is required to follow the procedure as highlighted in the discussions held above. Yes.
Please.
Respondent number 2 is at liberty to appear before the trial court. Yavaga.
On 16th, my lord. 16th of this month.
16th, this order should
Once I
reach
get the order, my lord, I'll approach the honor.
ಯಾವಾಗ ಅಂತ ನೋಡಿ. March 1st week ನಲ್ಲಿ March 3rd.
Oblige me.
3/3. Only respondent number 2 shall appear. The accused need not. Please.
Oblige me.
Allowed. Remanded in bail.
Number 7, be elected.
But the petitioner is accused number 2, Mula.
Accused number 2.
Please, there are 2 accused in the charge sheet.
One has not filed any.
Not filed any.
What is the offense?
But the 279 304A.
The RC owner has been implicated as accused number 2.
Accused number 2 is the RC owner.
RC owner.
What is the vehicle?
Vehicle, car, my lord, car.
Owner ಗೆ ಹೇಗೆ 279?
Yes.
That is the only ground?
That is the only.
Accused number 1 was the driver.
Driver has come the husband of the second accused.
Driver come husband. ಏನಿಲ್ಲ.
Please. The accused number 1 and 2 has not only been charge sheeted for the offence 279, 338, 304A, along with the offences under
279 ಮತ್ತೆ
279, 304A, along with section 146 and
ಕೊಡಿ, motor vehicles
196 of
act ಕೊಡಿ.
IMV Act.
ಇನ್ಶೂರೆನ್ಸ್ ಇರ್ಲಿಲ್ಲ.
In which it
ಇನ್ಶೂರೆನ್ಸ್
says,
ಇರ್ಲಿಲ್ಲ.
ಆಯ್ತು ಸರ್ ನಾನು ಹೇಳ್ಬಿಡ್ತೀನಿ ತಡೀರಿ. In which it says, my lord, section 146, no person shall use or allow any vehicle which is not insured, my lords, as per section 146 of IMV Act. And 196 of IMV Act, my lords, states penalizing section, my lords. Whoever has let the person with an vehicle without insurance. And in column number 7, my lords, the bottom two lines says, ರಲ್ಲಿ ನಮೂದಿಸಿರುವ ಆರೋಪಿ ಅಪಘಾತ ಮಾಡಿದ್ದ ಕಾರಿನ ಮಾಲೀಕನಾಗಿದ್ದು ಅಪಘಾತ ಸಮಯದಲ್ಲಿ ಸದರಿ ವಾಹನಕ್ಕೆ ವಿಮೆಯನ್ನು ನವೀಕರಿಸಿರುವುದಿಲ್ಲ. That is the sections attract against the present petitioner. That is under section 146 and 196. And
It is only 196 penal provision.
How?
146 also, my lords, because she being the owner, she has allowed her husband without insurance.
Penal provision 196 ತಾನೆ?
And 146 will explain.
146 is civil liability of covering the third party. Therefore, already they initiated MUC proceedings and compensation is awarded 45 lakhs.
Offences which attracts against the present petitioner is this, my lords.
ಇದು 196 ಕ್ರಿಮಿನಲ್ ಆಗುತ್ತಾ?
Please, my lords, this is offense.
Fine or 3 months ಇದೆ.
3 months.
Fine or 3 months.
ಹೌದು.
ಎಂಡ್ ಅಲ್ಲ.
ಹ್ಯಾಂಡಲ್. ಕೊಡ್ತೇನೆ.
ಅಷ್ಟೇ, ಅದಕ್ಕೆ ಪ್ಲೀಡ್ ಗಿಲ್ಟಿ ಮಾಡಿ ಫೈನ್ ಕಟ್ಟಿ.
But it is charge sheet together they filed entire IPC.
279 304A, how you can?
My lords, the charge column, my lords, separately they have mentioned only.
Now they are mentioning, the investigating officer mentioning against accused number 1, these are the offenses.
Please.
Against accused number 2, these are the offenses.
Please. Specifically, my lords.
279 and 304 you cannot invoke.
279, 304, I am not disputing with that, my lords. I am only concerned with respect to 146 and 196 of.
146 read with 149.
Yeah.
46 only civil liability. Already MUC proceedings are initiated.
Civil ಅಂತ ಮಾತ್ರ ಇದೆಯಾ? ಅಲ್ಲಿ ಪನಿಷ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅದು 196 ಅಲ್ಲಿ 146
is the offense. Contravention is 146.
Yes, yes.
Penal provision is 196.
My lords, 146 also there is a penal liability of 3
Idea.
months. My lords, section 146 of Motor Vehicles Act 1988 mandates that every motor vehicle must have valid third party insurance, while section 196 prescribes penalty for driving without it. Violate at space up to 3 months imprisonment, 2000 fine.
Step 146, necessity for issuance against third party risk. That is the requirement.
Yes.
If it is contravened,
196.
the consequence is 196.
Yes.
ಅಷ್ಟೇ 2000 rupees ಇದೆ, 3 months ಇದೆ, ಆರ್ ಬೋತ್ ಇದೆ. ಅಷ್ಟೇ. ಈಗ 279 304 ಗೆ ಅಲ್ಲಿ ಕ್ವಾಶ್ ಅಷ್ಟೇ.
That I am not disputing.
ಅಷ್ಟೇ ತಾನೆ?
ಅಷ್ಟೇ.
Petition by
being accused number 2. Petitioner being accused number 2 in CC 3947 of 2021, particularly crime number 109 of 2020 of Bangalore International Traffic Police Station, bracket complete, pending on the file of the learned principal civil judge and JMFC Devanandi, registered for the offence punishable under section 279 304A of IPC and under section 146 read with 196 of Motor Vehicles Act. Is seeking to quash the criminal proceedings initiated against him. Heard so and so. Raised point for consideration. My answer to the above point partly in the affirmative for the following reasons. Respondent number 2 filed the first information with so-and-so police station alleging commission of the offence punishable under section 279, 337, 304A of IPC. Police station BIAL Traffic Police Station. The FIR in crime number 109 of 2020 was came to be registered. After investigation, charge sheet came to be filed against accused numbers 1 and 2 for the above said offences. Accused number 2 is before this court seeking to quash the criminal proceedings. The only contention raised by the learned counsel for the petitioner is that section 279 and 304A of IPC could not have been invoked against the present petitioner, as she is only the owner of the car in question which caused the accident, while the same was being driven by accused number 1. Learned additional Brigadier General concedes this fact and submits that she has no objection to quash the criminal proceedings for the offence punishable under section 279 and 304A of IPC. However, he submits that there is contravention of section 146 of Motor Vehicles Act, which is punishable under section 196 of Motor Vehicles Act. Next one, admittedly, petitioner being accused number 2 was the owner of the offending car which said to have caused the accident, while the same was being driven by accused number 1. The concept of vicarious liability cannot be made against the petitioner and she cannot be called upon to answer for the offence under section 279 and 304A of IPC, when admittedly she was not the driver of the car in question at the time of alleged accident. Therefore, the criminal proceedings against the petitioner with the offence under section 279 304A of IPC is liable to be punished. Next para, regarding the section 146 of IPC, it refers to the requirement of insurance against third party risk, requirement of the vehicle to be insured against third party risks. The contravention of the same would result in invoking section 196 of the Motor Vehicles Act, which prescribes the penal provisions
prima facie, there are materials to constitute contravention of section 146, punishable under section 196 of Motor Vehicles Act, and therefore the criminal proceedings for the same is not required to be, is not liable to be quashed. In view of the above, I am of the opinion that the petition filed by the petitioner is liable to be allowed in part. Accordingly, I answer the above point partly in the affirmative and proceed. Petition is allowed in part. Criminal proceedings initiated in so and so for the offence punishable under section 279 304A of IPC is quashed. Yes. Liberty. That is not taken away.
Otherwise, you have to face trial there.
You can appear before. ಏನಾಗಿದೆ ಸ್ಟೇಜ್ ಏನಿದೆ ಈಗ?
Await further orders ಅಂತ ಇದೆ. ಇಬ್ರು enjoying.
Go before the learned magistrate. Say I am willing to plead guilty. Magistrate will be more than happy. We will record your plea.
Serial number 8 urgent. These two, serial number 1. For further hearing, B.S. Appanavar, B.S. Prasad.
ಯಾವುದು?
Serial number 1.
The present petition.
I have produced the discharge.
1 minute.
I have produced discharge summary. I am for even my lord. There are 24 info is on there. It is written my lord.
ಎಲ್ಲಿದೆ ಡಿಸ್ಚಾರ್ಜ್ ಸಮ್ಮರಿ? ಮಾಡಿದ್ದೀರಾ?
I have produced discharge.
My lordship, I have obtained the present medical condition report on the present medical condition.
21/1/2026 I have produced.
Now this petition is only on medical ground.
You are on merits also because some of these points from my lord, I am not permitted to argue of what I had argued at the time of consideration of first bail application. What are all the factors which are not brought to your lordship's notice at the time of the first bail petition? No, I am entitled to place before your lordship.
Why that was not addressed at that time?
I am coming to that part. But medical don't ask.
No. 1 minute.
Discharge somebody at request.
So you voluntarily got discharged.
That is the point to consider, my lord. Because my lord, A1 came to be arrested on 22, on 22/1/2025. A1 came to be arrested, my lord. Hereafter, my lord, since
No, petitioner is accused number 1.
Accused number 1. Petitioner accused number 1.
He was arrested on 24/1.
24/1/2025.
Last time you said 24.
But you were sent to JC on 24. He was taken to hospital. Under police custody, he was taken to hospital, my lord, because he was involved in the 302 case. Because the discharge of itself indicates that he was admitted to the hospital on 23/1/2025.
By whom?
3:25 AM.
By whom?
By the police.
ಎಲ್ಲಿದೆ?
Like the charge sheet.
My lord, in the on 24/1, he was given to judicial custody, my lord. He was arrested on 23/1. He was remanded to judicial custody on 24/1. And my lord, discharge somebody at request. It means the police, at the request of the police, the doctor discharged him.
No, not at the request of police. At the request of the patient.
You know, my lord, also can be appreciated because if he had been lodged in the hospital, four policemen would have to be deputed for.
ಅದಕ್ಕೆಲ್ಲ ಬೇಸಿಸ್ ಎಲ್ಲಿದೆ?
I will just take your lordship to.
ನೀವು ಸುಮ್ಮನೆ ಕತೆ ಹೇಳ್ಬೇಡಿ.
Charge sheet, my lord. Charge sheet, my lord. Your lordship may kindly have page number 57. Page number 57. Because if he had been lodged in the hospital, four policemen would have to be.
Sir, prima facie, I can see you yourself got admitted to the hospital, saying that, 1 minute, hear me for a while, saying that you got treated in Nirmala Hospital, Bhadravati, but no documents are available in support of the same. However, you are admitted to the hospital and at your request, you are discharged.
I'm really permitted to make submission. And if you still can have a look at this 57.
57.
Yes, and Toshira, even was remanded to GC. He was arrested on 24.
There is no dispute regarding your apprehension and remanding.
The wound certificate, page number 266, my lord. It is also shown in the wound certificate that page number 266, my lord. Wound certificate. The admission date was 23/1/2025 at 3:25. And he was discharged on 24/2/2025 at 7:24. Because thereafter he was produced into the magistrate. And the name has taken as demanded him to be custody. And the request means.
ಅಲ್ಲ ಏನು 266 ನಲ್ಲಿ ಏನಿದೆ? You got admitted to the hospital. ಸರ್ ಈ ಡಾಕ್ಯುಮೆಂಟ್ ನಲ್ಲಿ ಏನಾದ್ರೂ ಇದೆಯಾ? ಸರ್ ನಿಮಗೆ ಗೊತ್ತು wound certificate ನಲ್ಲಿ ಇರುತ್ತೆ accompanied by ಅಂತ ಇದೆಯಾ? ಪೊಲೀಸ್ ಅಂತ ಇದೆಯಾ? ನನಗೂ ಗೊತ್ತು ನಿಮಗೂ ಗೊತ್ತು. But we are bound by the documents.
This is act request because he was demanded to this JC.
That cannot be, that cannot proceed.
Take your lordships. I'll permitted to make one submission, my lord. Regarding the injuries which he has sustained, just take your lordship and attention to page number 260.
260?
260, my lord. Page number 260. My lord. Next page 261. To page number 260. My lord. Impressions. Page number 260. Impressions. He had injuries over 7 parts of spinal cord. L1, 2, L2, 3, L3, 4, L4, 5, L5, S1, L4, 5, L5, S1. He had injuries over 7 parts of spinal cord, my lord. This is the injuries he has sustained. And on page 261, page 261, and chronic small vessel.
ಸರ್ ಇದೆಲ್ಲ ಏನಿದು ಸ್ಕ್ಯಾನ್ ರಿಪೋರ್ಟ್ ಅಷ್ಟೇ ಇದು. ಆಯ್ತು, ಮೆಡಿಕಲ್ ಒಪಿನಿಯನ್ ಏನು ಇದ್ರ ಬಗ್ಗೆ? ಡಿಸ್ಚಾರ್ಜ್ ಸಮರಿ ಎಲ್ಲೋ ಹೇಳಿದ್ರಲ್ಲ, ಏನಿದೆ? ಮಾಡಿಸ್ಕೊಂಡಿದ್ದೀರಿ? ಮಾಡಿಸ್ಕೊಂಡಿದ್ದೀರಿ? What was your condition at the time of discharge?
Discharge time he had been badly assaulted. It's a fact, my lord, because
what is his condition at the time of discharge? Patient was conscious, obeying, DA or L reactive.
Page number 4. The discharge your lordship may kindly have a look on page number 4. Vomiting ante ide. Discharge vomiting but might be back pain. ಆಮೇಲೆ ಸಿಟಿ ಸ್ಕ್ಯಾನ್ ಗೊತ್ತಾಗಿತ್ತು.
ಎಲ್ಲಿದೆ ಅದು? ಎಲ್ಲಿದೆ? ಯಾವುದನ್ನು ರೆಫರ್ ಮಾಡಿ? ಪೇಜ್ ನಂಬರ್ 4 ಓದಿ.
ಮೇಲೆ vomiting ante vomiting discharge summary moving all four limbs ಕೆಳಗಡೆ vomiting plus might ಇದು ಯಾವಾಗ at the time of when he was being discharged from the hospital.
ಇಲ್ಲ ಅದೆಲ್ಲ ಇದೆಯಾ? ತಲೆನೋವು ಅದನ್ನ ಪೂರ್ತಿ ಓದ್ಬೇಕು. ವಾಮಿಟಿಂಗ್ ನಿಲ್ಲಿಸೋ ಹಾಗಿಲ್ಲ. ಓದಿ, ನಾನು ಓದ್ತೀನಿ ನಿಲ್ಲಿ. ತಲೆನೋವು, ಪದೇ ಪದೇ ವಾಂತಿ, ಮೂರ್ಛೆ, ಪಾರ್ಶ್ವವಾಯು, ಮುಖ ಸೊಟ್ಟ, ನಡೆದಾಡುವಾಗ ಬ್ಯಾಲೆನ್ಸ್ ಹೋದರೆ, ಕಿವಿ ಮೂಗಿನಲ್ಲಿ ನೀರು ಬಂದರೆ, ವಿಪರೀತ ಜ್ವರ ಬಂದರೆ, ಉಸಿರಾಟಕ್ಕೆ ತೊಂದರೆ ಆದರೆ ತಕ್ಷಣ ಸಂಪರ್ಕಿಸಿ. ಇದೆಲ್ಲ ಇದೆ ಅಂತಲ್ಲ, ಇದ್ರಲ್ಲಿ ಯಾವ್ದಾದ್ರು ಬಂದ್ರೆ ಬನ್ನಿ ಅಂತ ಹೇಳಿದರು.
CT scan 265 days. ಅಲ್ಲ ಆ ನಂತರ ಬರ್ತವೆ ಮ್ಯಾಟರ್. CT scan ಅವೆಲ್ಲ. ಆಮೇಲೆ 260 fracture is noted at left nasal bone. Page number 265. Fracture ಇದೆ. ಅದು ಈಗ badly assaulted. Page number 265. Fracture is noted at left nasal bone. ಆಮೇಲೆ left eye blur ಅಂತ ಅದು it is not a history. It is the finding of the doctor.
ಆಯ್ತು, ಇದು ಯಾವಾಗ ಜನವರಿನಲ್ಲಿ,
And in a merit mail.
ಜನವರಿನಲ್ಲಿ.
Then
ಈಗ ನಾವು ನೆಕ್ಸ್ಟ್ ಫೆಬ್ರವರಿನಲ್ಲಿ ಇದೀವಿ.
because, my lord, what I have political documents are pertaining to 192-25. 192-25. You were corrected on 24/1. Mental records.
ಹೌದು ಸರ್, ಜನವರಿ 25 ನಲ್ಲಿ ನಿಮ್ಮನ್ನ ನೀವು ಅಡ್ಮಿಟ್ ಆದ್ರಿ, ಡಿಸ್ಚಾರ್ಜ್ ಆದ್ರಿ, ಅರೆಸ್ಟ್ ಆದ್ರಿ, ರಿಮಾಂಡೆಡ್ ಟು ಜೆಸಿ.
260 page number. And date is the 190. Discharge date alla. You was taken treatment by law. He was treated on 192-25.
ಡಿಸ್ಚಾರ್ಜ್ ಸಮ್ಮರಿ ಇವತ್ತು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದನ್ನ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. ಡಿಸ್ಚಾರ್ಜ್ ಡೇಟ್ 24/1/25. ಹೌದು.
In an allowing petition, I have produced the medical certificates. You will also kindly have a look at page number 260. Adalli ide. He was treated. What I have produced documents.
That is only a scan report.
Adalli in the scan report it is shown that he was badly assaulted. He had injuries over.
Scan report ಮೇಲೆ ನಾವು we cannot form an opinion. There must be medical record.
That is the medical.
Scan report on produce ಮಾಡಿ badly assaulted ಅಂದ್ರೆ ಏನು ಹೇಳೋದು?
You know, I come to the merit.
Where is the medical report? ಈ ಸ್ಕ್ಯಾನ್ ಮಾಡ್ಬೇಕಾದ್ರೆ there must be some recommendation.
When the scan was done, then MRI is done. Then only.
At whose instance? Who recommended for MRI?
Because he was badly injured, he was being started providing treatment to the jail. But the jail, because he is in custody since more than 1 year. Regarding merits of the case, I am cutting. Those ones which are not urged before the lordship, at the time of hearing of the first case petition, I may permit to urge those.
As per this report, what is the opinion?
My lordship, all the treatment are given, my lordship. He has sustained some injuries, my lordship. In the page number 2, my lordship, the doctor has opened that, that is in second para, my lordship. It's a fresh dictated case of STN and initiated anti-hypertension drug. The MRI brain and spine performed on page number 2, my lordship. At the end, my lordship, at the end, fourth line, the neurosurgeon diagnosed tension type headache for the same psychiatric opinion taken and conservative management was done. Ophthalmology opinion was taken for dimension.
Today, page 2 na.
Indian, my lordship. That is the one, my lordship. That is the one.
Idu.
First page is the report from the police. Second page is the opinion of the doctor, my lordship.
ಹೌದು, ಅದರಲ್ಲಿ ಎಲ್ಲಿದೆ?
ಅದರಲ್ಲಿ second paragraph ಅಲ್ಲಿ last fourth line, my lordship. The neurosurgeon diagnosed tension type headache for the same psychiatric opinion taken and conservative management was done. Ophthalmology opinion was taken for dimension of vision and was diagnosed with left eye rate O2 pterygium was advised extension on 17/9/25. At present, patient is on medication as advised by higher center, McGann Hospital, Shimoga, and is on regular follow-up.
Yes.
All the treatment and care is taken care, my lordship.
Yes.
The JC.
I am told that when he was taken to the hospital for second time, neurosurgeon was not there. Is what I am told.
What was not there?
Neurosurgeon was not in the hospital. And my lord, because lordship on the earlier occasion, I will take the lordship to kind attention to page number 301 at the observation field by lordship in the order. Page number 301 column A. Your lordship solely was pleased to reject the bail application on the ground that A1 has not produced any medical certificates, but what your lordship was pleased to observe that except the police information given by the private hospital regarding the fact of the we have approached the hospital with a clear facade. There is no mention regarding sustaining of any injury by 1-3. In the police intimation, your lordship didn't find anything as to whether they had sustained injuries or not. On that point, your lordship was free to reject the application. And my lord,
Accused number 2 and 3 still in GC.
They are accused 1 to 3 are in judicial custody, my lord. A4 has been released on bail by your lordship, and your lordship will kindly appreciate. There is not even a single allegation in the complaint as to whether A1 has assaulted either with hands or with weapon. Rather, he was badly assaulted. There is no allegation. I mean, and one more thing, your lordship will kindly appreciate. That was not brought to your lordship kind attention at the time of freedom of the lordship. What is the case of the prosecution, my lord? A1 and A4 picked up this cover with the deceased. At the time of cover, A2 and A3 brought the choppers from the house and they assaulted the deceased. So it is not the case of the prosecution as to whether A1 had instructed A2 and A3 to bring the choppers. Because when the scuffle was going on, A2 and A3, they came with the choppers. It is not A1 who told them to bring the choppers. So there is no, my lord, premeditation, pre-planning, and one more thing, my lord. The alleged offense has taken place in front of the house of A1. That's very important, my lord, because the deceased hails from Doteri. My lord, the deceased hails from Doteri. The incident has taken place in MA-Doti. MA-Doti is 1 kilometer from Doteri. Deceased is the name of Doteri. Incident has taken place in MA-Doti in front of the house of A1. So that itself shows that there was no pre-planning, premeditation, intention, preparation. In a spur of moment, the incident had taken place. The incident has taken place in front of the house of A1.
Whether he sustained any injury in the incident?
It is alleged that A3 has assaulted the deceased with the chopper on the calf, left calf. A2 has assaulted the deceased on his back with chopper. But A1 has not assaulted either with hands.
The contention of the prosecution is that you are the kingpin, you are the mischief monger.
Yes,
You had the motive to cause the death of the deceased.
Then your lordship.
At your instigation, accused number 2 and 3 have assaulted.
My lord, your lordship knows very well regarding the principles of criminal jurisprudence. My lord, the incident has taken place in front of the house of A1. Is the first point I must say, because it is not the accused who chased the deceased or they went to the Doteri to assault A1. So there was no intention to lynch him. This is one thing.
We have the prosecution case. The deceased was proceeding on the public road on his motorcycle.
Yes.
At that time, you waylaid them. A1 to 3 waylaid him.
No.
And you instigated accused number 2 and 3 and assaulted him.
My lord, I am give permission to make one submission. It is A1 when the scuffle started. It was only A1 and A4 where at the stop. It is the case of the prosecution, not my case. And A2 and A3 later came with choppers, my lord.
Yes.
So where is the scope for A1 to abet A2 and A3?
Where is the charge sheet?
Yes, charge sheet. I will complaint. I may permit to read complaint.
Beda ivaga charge sheet hakidare.
Charge sheet.
Then come to page number 72.
Column number 17 I will read my lord police. Ella CC charge barita. So now I have the complaint to page number 16. Type copy page number 20.
Sir, complaint ಆದ್ಮೇಲೆ investigation ಆಗಿದೆ. After full-fledged investigation, final report is filed.
Yes.
That is the allegation against the accused now.
Page number column number 17, page number 72. Alle.
What is the allegation against you?
Yes, madam.
What is the allegation against this petitioner?
A1, according to the contents of paragraph 17 of charge sheet, my lord, this is the case of the prosecution that A1 and A4 picked up this scuffle with the deceased. When the scuffle was going on, A2 and A3 came with the choppers. It is not A1 who instructed A2 and A3 to bring the choppers, my lord.
No. Accused number 1 to 3 were together at the spot there.
It is not like one is arrest. Then I will take the lordship, your lordship can listen to statements of the witnesses, 161 statements. In 161 statement, because this is the charge made by the police. 161 statement.
Sir, in all the cases, the investigation will be held by the police only.
Then that should come in the statement of the witness. case is
Very strange argument you are addressing.
CW 2 to 5 are the eyewitnesses. CW 2 to, in the case of the constitutional death, CW 2 to 5 are the eyewitnesses. Now, I will tell the statement of CW 2, page number 139. Page number 139. Statement of CW 2. Last 8 line, now go to the actually image of this school.
Page number?
Page number 139. In page number 139.
139 is inquest master. Two?
Page number 240. 240. I'm sorry. That is the statement of CW 2. Recorded in section 180 of BNS. Last 9 line. Last statement. 214. It is a statement of Satya alias Satish eyewitness. I will permit it last time. Actually, MA Dodge school hantira Lepaxi A1 Shanugopal A4 Shankumar ಅಡ್ಡಗಟ್ಟಿ ಕರೆದು ನಿಲ್ಲಿಸಿಕೊಂಡು ರೇಪಾಕ್ಷಿ ಜೋರಾಗಿ ಮಾತನಾಡುತ್ತಾ ಅತೀಶ್ ಮತ್ತು ಅಭಿರವರಿಗೆ ಈ ಬೋಯ್ಗಳು ನಮಗೆ ಎಲ್ಲ ಕೆಲಸ ಕಟ್ಟಿ ಬರ್ತದೆ ಜೀವ ಬಿಡುವಾಗ ಬೈದಿದ್ದನು ಆಗ ಅತೀಶ್ ಮತ್ತು ಅಭಿರವರು ತಮ್ಮ ಬಳಿ ಇದ್ದ.
So all the four were together at this spot.
I will take a lordship this starting.
Your theory that accused number 2 and 3 were not there, it will not get support.
My lord, Ramesh, ಹೋಗುತ್ತಿದ್ದೆವು ಅಷ್ಟರಲ್ಲಿ ಏನಾದ್ರು ಸ್ಕೂಲ್ ಹತ್ತಿರ ರೇಪಾಕ್ಷಿ ಅವರ ಅಣ್ಣ ಶಿವಕಪ್ಪ ಶಾಂತಮಾರ ಅಡ್ಡಗಟ್ಟಿ ನಿಲ್ಲಿಸಿಕೊಂಡು ರೇಪಾಕ್ಷಿ ಜೋರಾಗಿ ಮಾತನಾಡುತ್ತಾ ಅತೀಶ್ ಮತ್ತು ಅಭಿರವರಿಗೆ ಫಸ್ಟ್ ಆಕ್ಚುಲಿ ಇನ್ಸಿಡೆಂಟ್ ಆಗಿತ್ತು ಇವನ್ A1 ಮತ್ತು A4 ಸ್ಪಾಟ್ ಆಗಿತ್ತು. ನಂತರ A2 A3 ಬರ್ತಾರೆ. ಆಮೇಲೆ ದೇರ್ ಆಫ್ಟರ್ ಮೈ ಲಾರ್ಡ್ ಈ offense ಆಗಿರೋದು as I have already submitted, it is in the near the house of A1. Motive, intention. At the most, it will fall at the later part of section 304, part 1 minor. At the later part of section 304, part 1. So, DNS 105, part later part of 105, DNS. And motive is missing. And my lord, A1 stands on the same footing on which A4 stands. A4 is granted here, my lord, and there is no word act against A1 because I mean nothing. A1 is not required for any purpose because he is already in judicial custody since more than 1 year, my lord. Since 1 year he is in judicial custody. Our kaili nodudilla, weapon indu nodudilla. Motive, there is no motive. There is no intention. There is no preparation, and there is no premeditation. There are relations A2 and A3. And A4 is already granted bail. Why I am seeking for requesting for bail on the ground of clarity also? The reason is that A1 stands on the same footing on which A4 stands, my lord. A1 and nothing is seized from A1, my lord. Nothing has been seized from A1 in the judicial custody since more than 1 year, 1 month. More than 1 year in judicial custody. And there is no word like against him. Nothing has been seized from him.
When he was arrested?
Yes, ma'am.
Arrested on?
24/1/2025. And purpose is not resolved by keeping behind the bars who has not yet assaulted admitted.
Yes, what is?
My lordship, in the charge sheet, there is a clear allegation against the A1 that he is the kingpin for the commission of the offense, my lordship, and he is the instigator, my lordship. He is the main instigator.
Not armed with any weapon.
He was not armed with any weapon.
There is no recovery at his instance.
Please, my lordship, there is no recovery.
Accused number 2 and 3 are in JC.
Yes, my lordship, they are in
They were
JC.
armed with longs.
Yes, my lordship. They were only assaulted, my lordship.
Where is the postmortem report? How many injuries were?
Page number 121. And the relevant page injuries are shown. Page 1, first page is reading. injuries. There are totally 12 injuries, my lord.
124, the opinion of the doctor of the postmortem, my lordship. Death was due to, my lordship found it, 124.
Case number 121.
Death was due to shock and hemorrhage as a result of injuries sustained. However, the deceased had injured
Always,
to some substance.
even vision, I didn't bring your assessment attention. PM report indicates that, my lord.
Where is the final report? This is only provisional report.
124, my lordship.
My lord, the deceased had ingested some substance containing ethyl alcohol. Prior to his death, and the blood ethyl alcohol concentration was up to 43.97 mg per 100 ml. Because the deceased was highly intoxicated, my lord. That finds a place in the PM report.
Intoxication ಅಂದ್ರೆ ಹೋಗಿ ಕೊಂದು ಬಿಡುದನ then ಹಾಗಿದ್ರೆ ಎಲ್ಲರನ್ನೂ ಕೊಂದು ಬಿಡ್ಬೇಕು ಇಲ್ಲಿ. That cannot be the justification, sir.
My submission means in a state of highly intoxication, he was a part of mass assault. What I want to say. And my lord, admittedly, it is the case of the prosecution. A1 was unarmed, nothing had been seen from A1. He has not asserted this is a plan for any
ಈಗ
member.
ನೀವು ಸುಮ್ಮನೆ ಇದ್ರೆ ಏನಾದ್ರೂ ಕನ್ಸಿಡರ್ ಮಾಡ್ತೀನಿ. Straight away I'll dismiss the petition if you go on making such submissions.
Sorry.
How many injuries? 12 injuries.
Please, my lordship.
Petitioner being accused number 1 in special case number 5011 of 2025, pending on the file of the learned 4th additional district and sessions judge Shomaga, sitting at Bhadravati, registered for the offence punishable under sections 352, 351(2), 103(1), 3 bracket 5, 126(2), section 55 of Bharatiya Nyaya Samhita BNS for short, and under sections 31 RS 32V of SC/ST Prevention of Atrocities Act, and under sections 325 1B of Arms Act. He is seeking grant of bail and release from custody. Heard affirmative for the following reasons. The petitioner, the FIR came to be registered against accused numbers 1 to 4 on the basis of the first information lodged by the informant Srimati Vedavati. After investigation, charge sheet came to be filed against them for the aforesaid offences. It is the specific contention of the prosecution that there were two groups in the village who were quarreling with one another very frequently. On the date of incident, ಅದನ್ನು full page 300 ನಲ್ಲಿದೆ para 5, 6. earlier order. Next part. It is stated that accused number 1 to 3 were having ill will against the deceased as they suspected that the deceased informed their ill deeds to the panchayat officials, which led to the incident in question and death of the deceased. After full-fledged investigation, the investigating officer found that accused number 1 to 4 were at the spot when the deceased was waylaid near electric transformer while proceeding on a motorcycle. It was accused number 2 and 3 who were armed with long, and they assaulted the accused, as a result of which the deceased has sustained as many as 12 injuries, which include lacerations, abrasions, stab wounds, contusions, chalk wounds, or incised wound. Admittedly, this petitioner was not armed with any weapon, nor there is any recovery at his instance. CW 2 to 5 are cited as eyewitnesses. Their version disclosed that it was accused number 2 and 3 who were armed with weapons assaulted the deceased, which resulted in his death. The allegation made against the petitioner is that he is the main accused who instigated accused number 2 and 3 to cause the death of the deceased. But the fact remains that the injuries that were found on the dead body were caused by accused number 2 and 3 and not by the present petitioner. Next part. The petitioner had filed criminal appeal number 1, 2, and 6 of 2025, seeking grant of bail. The same was came to be dismissed with a judgment dated 21/7/2025. Thereafter, the present appeal was came to be filed. Even though the bail was sought on the ground of on medical grounds, I do not find any support to enlarge the petitioner on bail on medical grounds. But however, since the petitioner was not armed with any weapon, and he is not, admittedly, he is not the author of the injuries caused to the deceased, since there were no recovery of incriminating materials at the instance of the present petitioner, I am of the opinion that the petitioner may be enlarged on bail subject to conditions. When admittedly the petitioner was apprehended on 24/1/2025, his detention in custody till conclusion of trial will infringe his right to life and liberty. Reasonable conditions may be imposed. Yes. Allowed, subject to conditions.
Next.
Serial number 2, P. Karnataka, K. Chandrasekhar.
My lord, kindly pass over, my lord. I am the party in this responding, my lord. My senior will head up in another court. Kindly pass over, my lord.
CD, they said that there was a CD of the voice record. But it is not a part of the
CD is part of charge sheet.
But even there is no FSL report. It's not there.
ಇದೆ ಲಾಸ್ಟ್ ಅಕೇಶನ್ ಅಲ್ಲಿ ಕೋರ್ಟ್ ಮುಂದೆ ತೋರಿಸಿದ್ವಲ್ಲ ಅದು ನೋಡಿನೇ ರೆಕಾರ್ಡ್ ಮಾಡಿದ್ದು.
No, CD is part of charge sheet. ಎಲ್ಲಿದೆ ನೋಡಿ.
ಪೇಜ್ ನಂಬರ್ 13 13 ಅಲ್ಲಿ ಇದೆ. 13
ಔಟ್ ಶೀಟ್ ನಲ್ಲಿ ತಗೊಳ್ಳಿ. ಇದು ಇವತ್ತು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದ ಯಾರು ಮಾಡಿದ್ರು? Then
There was a direction
produced
ಅಲ್ಲಿದೆ ನೋಡಿ.
sheet. Copy of the charge sheet.
ಕುತ್ತೆ ಸಂಬಂಧ ಆದ
Police inspector.
ಅಲ್ಲಿದೆ ಪೇಜ್ ನಂಬರ್ 13.
Police station. ಅದು ಔಟ್ ಶೀಟ್ ನಲ್ಲಿ. Where is reference to CD?
My lordship, Patricia. Page number 13, my lordship. It is mentioned.
ಎಲ್ಲಿ 13 ಎಲ್ಲಿದೆ? ಪೇಜಿನೇಷನ್ ಎಲ್ಲಿದೆ? ಪೇಜಿನೇಷನ್ ಇಲ್ಲ 13 ಅಂದ್ರೆ.
ನಮ್ಮ ಚಾರ್ಜ್ ಶೀಟ್ ನಿಮ್ಮ ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಇದೆ.
ಇವೆಲ್ಲ ಬೇಸಿಕ್ಸ್ ಇವೆಲ್ಲ. ಬೆಳಿಗ್ಗೆ ಅಂದ್ರೆ ಇವಾಗ ಎಷ್ಟಾಯ್ತು? 12:30 ಆಯ್ತು, 12:40 ಆಯ್ತು. ಅಷ್ಟೇ ಮೆಕ್ಯಾನಿಕಲಿ ಏನೊಂದು ಮಾಡೋದು ಅಷ್ಟೇ. Where is the transcription?
Transcription is along with the charge sheet. CD is
ಎಲ್ಲಿದೆ? This is the CD. Copy of the CD. ಅದರಲ್ಲಿ copy of the charge sheet and copy along with the copy of the CD is said to be part of the final report. ಅಷ್ಟೇ. You know what is the name of the accused? Basuraj.
Basraj is accused number 1.
ಶಿವಣ್ಣ ಯಾರು?
Shivanna is brother.
Accused Basuraj is the father of the girl.
Nagaraj.
Basuraj is husband of the girl.
ಮತ್ತೆ ಇದೇನು ಟ್ರಾನ್ಸ್ಕ್ರಿಪ್ಷನ್ ಏನು ಯಾವ ರೀತಿ ಇದೆ?
No FSL, the CD was not there. Now they are calling the accused, saying that anyway it is not the video. There was no, it was not.
ತಡೀರಿ ಸರ್, ಅದೇನು ನೋಡೋಣ, ಸ್ವಲ್ಪ ಇರಿ, ಅದನ್ನೇ ಹೇಳ್ಬಿಡಿ. ಇದೇನು ಹುಡಿಯ ತಂದೆ ಬಸವರಾಜರವರ ನಡುವಿನ ಸಂಭಾಷಣೆ ಅಂದ್ರೆ? ಕಲ್ಕೇರಿ ಶಿವಣ್ಣ ಮತ್ತು ಹುಡಿಯ ತಂದೆ ಬಸವರಾಜ್ ಅಂದ್ರೆ ಏನು?
Is relative of Shivan is
ಹುಡಿಯ ತಂದೆ ಅಂದ್ರೆ
ಅವರು ಬಸವರಾಜು.
ಏನು ಹಾಗಂದ್ರೆ?
ಅವರಿಬ್ಬರ ಮಧ್ಯೆ ಅವ್ರಿಗೆ ಫೋನ್ ಮಾಡಿದ್ದಾರೆ.
ತಂದೆ ಸರ್ ಅವರು.
ಬಸವರಾಜು is the father of the respondent number 2 complainant.
ಹುಡಿ ಅಂತ ಹೆಸರು ಅವ್ರದ್ದು.
ಹೌದು.
ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 2.
Respondent number 2.
ಹುಡಿ.
ರೇಖಾ ಹುಡುಗಿ ಅದು ಅವರಿಬ್ಬರ ಮಧ್ಯೆ ಡಿಸ್ಕಷನ್.
ಫಾದರ್ ಆಫ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 2 is ಬಸವರಾಜ್.
ಹೌದು.
ಅವರಿಬ್ಬರ ನಡುವೆ ಆದ್ರೆ ಏನಂತ?
ಅವರಿಬ್ಬರ ಮಧ್ಯೆ ಡಿಸ್ಕಷನ್.
ಶಿವಣ್ಣ ಯಾರು?
ಶಿವಣ್ಣ ರಿಲೇಟಿವ್ ಆಫ್ the.
We are not concerned about that.
No, not concerned.
Which is the transcription relevant? ಕೊಡಿಯಲ್ಲಿ
Copy.
ಎಲ್ಲಿ?
And the last date, with the kind permission of the court, the last date of hearing with regard to the decree passed by the honorable for the dissolution of marriage, the respondent number 2, I am filing a memo along with the copy. Respondent number 2, that is the complaint, had approached the Sambal court in MFA proceedings. In MFA 3015 of 2025. This Sambal court, page number 2 nalli, on 25th April 2025, passed the order, interim stay of the impugned judgment and decree till further orders ಅಂತ ಹೇಳಿ. The
ಏನಿದು what is MFA 3015?
MFA dissolution of marriage was dissolved by the trial court. Against the other side submitted that marriage is dissolved. Now against the said judgment and decree, the respondent number 2 complaint approached the Sambal court in MFA proceedings MFA 3015 of 2025. On 25th April 2025, the Sambal court passed the order, interim stay of the impugned judgment and decree till further orders ಅಂತ ಹೇಳಿ ಆಗಿದೆ.
And what are the materials, sir?
Please, madam. Materials, my lord.
Some prima facie materials to
Please, madam.
constitute the
On the last date of hearing, my lord, it was question, 2 questions, my lord. One with regard to the delay ಅಂತ ಹೇಳ್ಬಿಟ್ಟು FIR ಅಲ್ಲಿ column number 3 ನಲ್ಲಿ occurrence of the day, occurrence of the offense day ಅಲ್ಲಿ from 29/1/2012 till 27th March 2017. That is the date of marriage till the date of filing of the complaint. It is noted in the.
That is why it is said it is barred ಅಂತ.
But ಬರೋದಿಲ್ಲ ಸ್ವಾಮಿ.
Allegations.
2017.
ಮದುವೆ ಆದಾಗಿಂದ FIR ರಿಜಿಸ್ಟರ್ ಆಗುವವರೆಗೂ
ಹೌದು ಅವರು ಆಫ್ಟರ್ ಮನೆಯಲ್ಲಿ ಇಲ್ದೇ ಇರೋದಕ್ಕೇನೆ ಕಂಪ್ಲೇಂಟ್ ಮನೆಯಿಂದ ಕಳ್ಸಿದ್ರು ಅವರು ಡ್ಯೂರಿಂಗ್ ಪ್ರೆಗ್ನೆನ್ಸಿ ಕಳ್ಸಿದ್ರು ಡೆಲಿವರಿ ಆಫ್ ಚೈಲ್ಡ್ ಕಳ್ಸಿದ ಮೇಲೆ ನೀನ್ ಹಣ ತಗೊಂಡ್ಬರ್ಲಿ ಬರೋ ತನಕ ನಮ್ಮ ಮನೆಗೆ ಬರ್ಬೇಡ ಅಂತ ಹೇಳಿದ್ರೆ ಇಟ್ ಅಮೌಂಟ್ಸ್ ಟು ಕಂಟಿನ್ಯೂಸ್ ಆಫ್ ಕಾನ್ವರ್ಸೇಷನ್ ಅದೇ ಸಿಡಿ ನಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಅವರು. ಅದು ರಿಗಾರ್ಡಿಂಗ್ ಶಿವಣ್ಣ ಮತ್ತೆ ಅವ್ರ ಮಧ್ಯೆ ಸಿಡಿ ನಲ್ಲಿ ಇರ್ಬೇಕಂತಿಲ್ಲ ಸ್ವಾಮಿ. FIR ಅಲ್ಲಿ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಹೇಳಿದ್ದಾರೆ.
ಸಿಡಿ ನಲ್ಲಿ there is no conversation between the accused and the
ಅದು ನನ್ನ ಕಡೆ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ಅವರು. ಅದು ನಾವು ಪೊಲೀಸ್ನವ್ರಿಗೆ
ನೀವೇ ಕೊಡ್ಬೇಕಲ್ವಾ ನಿಮ್ಮ ಹತ್ರ ಕಾನ್ವರ್ಸೇಷನ್.
ಪೊಲೀಸ್ನವ್ರಿಗೆ ನಾವು ಒರಿಜಿನಲ್ ಸಿಡಿ ನ ಕೊಟ್ಬಿಟ್ವಿ.
ಸಿಡಿ ನಲ್ಲಿ ಏನಿತ್ತು
ಇವಾಗ ನಾವು ಪೊಲೀಸ್ನವ್ರ ಹತ್ರ ಕೇಳಿದಿಕ್ಕೆ ಅದು ನಾವು ಕೋರ್ಟ್ ಗೆ ಕಳಿಸ್ತೀವಿ ಥ್ರೂ ಪ್ರಾಸಿಕ್ಯೂಷನ್.
ಲಾಸ್ಟ್ ಟೈಮ್ ಯು ಮೇಡ್ ಎ ಸಬ್ಮಿಷನ್ ಬಿಫೋರ್ ದಿಸ್ ಕೋರ್ಟ್. ಕಾನ್ವರ್ಸೇಷನ್ there was a conversation
ಇದೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು
disclosed demand of dowry.
ಹೌದು.
There was conversation which evidenced the harassment.
ಅದನ್ನ ನಾವು ಇವಾಗ ಹ್ಯಾಂಡ್ ಓವರ್ ಮಾಡಿದ್ವಿ. ಅವರು ಇಂಟರ್ನ್ ಕೋರ್ಟ್ ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ದಾರೆ.
ಅದಕ್ಕೆ ನಿಮ್ ಪ್ರಕಾರ ನೀವು ಹ್ಯಾಂಡ್ ಓವರ್ ಮಾಡಿದ್ದು ನಿಮ್ ಪ್ರಕಾರ conversation between whom?
Conversation between the father of the complainant and Shivanna in relation to the matter of this respondent number 2 and accused.
Father of complainant and Shivanna yaru?
Shivanna relative of accused number 1, accused.
Not with the accused.
ಇಲ್ಲ. ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಈಚ್ ಅಂಡ್ ಎವ್ರಿ ಲೈನ್ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಇವ್ರ ಮೇಲೆ ಹರಾಸ್ಮೆಂಟ್ ಸಂಬಂಧಪಟ್ಟಂತೆ ಎಗೇನೆಸ್ಟ್ ಆಲ್ ದ ಅಕ್ಯೂಸ್ಡ್. ಅಕ್ಕ ಜಯಮ್ಮ, ಅಣ್ಣಂದಿರಾದ ಮೂರ್ತಿ ಅಕ್ಯೂಸ್ ನಂಬರ್ 3, ಸೋಮಣ್ಣ ಅಕ್ಯೂಸ್ ನಂಬರ್ 4, ಲಿಂಗರಾಜು ಅಕ್ಯೂಸ್ ನಂಬರ್ 5, ಅತ್ತೆ ನಾಗಮ್ಮ ಅಕ್ಯೂಸ್ ನಂಬರ್ 6, ಮಾವ ಮರಿ ವೆಂಕಟಯ್ಯ ಅಕ್ಯೂಸ್ ನಂಬರ್ 7 ಮತ್ತು ಅವರ ಬೀಗರು ಅರ್ಸಪ್ಪ ಅಕ್ಯೂಸ್ ನಂಬರ್ 8 ದೊಡ್ಡದಾಗಿ ಗಲಾಟೆ ಮಾಡಿ ನಾವು ಕೇಳಿದಷ್ಟು ಹಣ ಕೊಡುವವರೆಗೂ ನೀನು ತವರು ಮನೆಯಲ್ಲೇ ಇರು, ಹಣ ಹೊಂದಿಸಿಕೊಂಡು ಬಾ, ಮನೆಗೆ ಅಲ್ಲಿವರೆಗೂ ನಿನ್ನ ಅಮ್ಮನ ಮನೆಯಲ್ಲೇ ಇರು ಎಂದು ದೈಹಿಕ ಮತ್ತು ಮಾನಸಿಕವಾಗಿ ಹಿಂಸೆ ಕೊಟ್ಟರು. ಇನ್ಸೋಫಾರ್ ಎಸ್ ಮೆಡಿಕಲ್ ಸರ್ಟಿಫಿಕೇಟ್
ಆಗಿದೆ. Mere allegation is not sufficient according to the present the settled position of law. There must be some prima facie materials to constitute the offense. Allegations we can make to any extent.
Physical assault ಬಗ್ಗೆ physical
decisions of the apex court as well as this court says apart from mere allegations there must be some material.
ಇದರಲ್ಲಿ
ಅದಕ್ಕೆ ನಾನು ಕೇಳಿದ್ದು ನೀವು ಹೇಳಿದ್ರೆ ಸಿಡಿ ಇದೆ ಅಂತ ಪ್ರೊಡ್ಯೂಸ್ ಇಟ್ ಅಂತ ಹೇಳಿದ್ದೀನಿ. ಈಗ ಡೋಂಟ್ ಗೋ ಅಗೈನ್ ಟು ದಿ ಪಾಯಿಂಟ್ ನಂಬರ್ 1. No, that is not sufficient.
This is the case, my lord, where charge sheet is submitted. It is for the accused, my lord, since detailed allegation has been narrated in the complaint and investigation material. It is for the accused to seek an order of discharge before the concerned trial court, not a case under 482 is my submission.
Yes.
ಮತ್ತೆ ಲಾಸ್ಟ್ ಇನ್ನು even now, insofar as the offense punishable under section 3 and 4 of DP Act ಕೂಡ ಕೊನೆಯಲ್ಲೂ ಕೂಡ ಹೇಳಿದ್ದಾರೆ. ಏನು ಲಾಸ್ಟ್ ಸೆಂಟೆನ್ಸ್ ಅಲ್ಲಿ ನಾನು ಕೇಳಿದಷ್ಟು ವರದಕ್ಷಿಣೆ ಕೊಡಿಲ್ಲ ಅಂದ್ರೆ ಡೈವರ್ಸ್ ಕೊಡುತ್ತೇನೆ ಎಂದು ಎದುರಿಸಿದ್ರು. ಮತ್ತೆ ಒಂದು ಪೇಜ್ ನಂಬರ್ 2 ನಲ್ಲಿ ಕೊನೆಗೆ ಕಟ್ಟಿರುವ ಮನೆ ಬೇಕು, ಬೆಂಗಳೂರಿನಲ್ಲಿ ಕಟ್ಟಿರುವ ಮನೆ ಬೇಕು, ಅಥವಾ ಒಂದು ಇನ್ನೋವಾ ಕಾರು ಕೊಡು ಎಂದು ಅವರ ಬೀಗರು ಅರ್ಸಪ್ಪನವರು ನಮ್ಮ ತಂದೆಗೆ ಫೋನ್ ಮಾಡಿ ಹೇಳಿದರು. ಇದನ್ನೆಲ್ಲ ಕೊಡಲು ಸಾಧ್ಯವಾಗದಿದ್ರೆ ಡೈವರ್ಸ್ ಕೊಡುತ್ತೇವೆ ಎಂದು ಬೆದರಿಸಿದರು. 3 and 4 DP Act ಕೂಡ ಅಟ್ರಾಕ್ಟ್ ಆಗುತ್ತೆ ಇದರಲ್ಲಿ. ಅಂಡರ್ 482 my lord, many trial cannot be conducted ಅಂತ ಹೇಳ್ಬಿಟ್ಟು number of citations are there. They can approach the honorable learned trial court where the case is pending, seeking an order of discharge since the offense alleged is cognizable offense. Charge sheet is submitted against them for cognizable offense.
After recalling the decree for divorce in MC 79, when it was again allowed? When? Date?
February 2025. 2025 after the
Initially, it was allowed on 12/2/2015. Yes.
And it is after that, 2 years later, the complaint was filed. In fact, before that, one notice was issued for
Yes.
restitution of conjugal right. It was duly served on the complainant. There was no reply. And this notice was also served on the respondent, that matrimonial case, MC. And she kept quiet. Later, she files an application to recall the same.
The legal notice was for restitution.
Okay.
That
Legal
is-
notice was for restitution, or that was my lord order. That was on 6/2/2014. That was duly served on her. There is no reply. And in fact, this petition was also initially allowed actually based on that. Thereafter, they filed one more application.
I think.
Even one submission my lord. 2012 ಆದ್ಮೇಲೆ 2014 ಅಲ್ಲೂ ಕೂಡ ಒಂದು ಕಂಪ್ಲೇಂಟ್ ಫೈಲ್ ಮಾಡ್ತಾರೆ, which was registered in NCR, which is marked as exhibit P5 and P6 in MMTC before the trial go MFA proceedings ಅಲ್ಲಿ. I am placing on record that exhibit P5 and P6 ಅಂತ ಹೇಳಿ ಮಾರ್ಕ್ ಆಗುತ್ತೆ. 2014 ಅಲ್ಲೂ ಕೂಡ ಒಂದು ಕಂಪ್ಲೇಂಟ್ ಫೈಲ್ ಮಾಡ್ತಾರೆ.
ಯಾರು ಕೊಟ್ಟಿದ್ದು?
This is a very complaint. ಹೌದು.
Yes.
My lordship, in the charge sheet, my lordship, there is a clear allegation that when she went for the delivery of the child, my lordship, they just mentioned, said that without giving site and car and the amount, they are not going to take back her and they are going to.
Allegation ಆಯ್ತು ನಾನು ಕೇಳ್ತಾ ಇರೋದು repeatedly, this is the last time I am requesting you. This is the last date of hearing, you said there is a conversation in support of the such allegations. That is why it is posted today. ಮತ್ತೆ ಮತ್ತೆ ಅದನ್ನೇ ಕೇಳಲ್ಲ ನಾನು.
The conversation, my lordship.
According to you, you produced the CD.
Please,
What is there in the CD? Whose conversation is there in the transcription? ಇಷ್ಟೇ ಕೇಳ್ತಾ ಇದ್ದೀನಿ.
Transcription is there, my lordship.
That conversation between whom?
Between Shivanna and also Basuraju and many other people, relatives, my lordship.
But not the accused.
Not that.
How it will help you? You consider the sequence of events,
Yes,
everything. See, according to him, there was earlier complaint. The complaint specifically states divorce notice bandide ಕೂಡಲೇ ನಾನು complaint ಕೊಟ್ಟಿದ್ದೀನಿ. And there is no allegation of dowry harassment, dowry demand, payment, acceptance, nothing. Even though it runs into 4 pages. First ಗೆ restitution ಗೆ notice ಕೊಟ್ರು, ನಾ ಹೋದೆ, ಆಮೇಲೆ ಡೈವರ್ಸ್ ಗೆ ನೋಟಿಸ್ ಕೊಟ್ರು, ಅದರಿಂದ ಈ ಕಂಪ್ಲೇಂಟ್ ಕೊಡ್ತಾ ಇದ್ದೀನಿ. What does it mean?
After receiving the notice, she has filed the complaint.
Then what opinion the court has to form? So, use the materials, point to consideration.
My last submission, my lord, the Honorable Court expressed that, my lord, a recent decision insofar as 498 is concerned. It is against in-laws and other relatives insofar as husband is concerned, my lord. He is liable for prosecution.
ಯಾವುದು citation?
Please,
ಯಾವ citation? In-laws against ಮಾತ್ರ.
a number of additions are there, my lord. Placed on record, my lord, by 230.
Sir, there must be prima facie materials against any accused for that matter.
So far as in-laws is concerned, my lord, the
In-laws ಮಾತ್ರ ಅಂತ ಹೇಳಿಲ್ಲ. Even husband ಕೂಡ. He is also one of the accused.
Husband
He is the main accused.
Husband is the liable for prosecution, my lord, under 498.
When serious allegations are made against him, when your earlier complaint also, it is only ಗಂಡನ ವಿರುದ್ಧ. What is the allegation? Restitution of conjugal rights ಗೆ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ರು, ಆಮೇಲೆ ಡೈವರ್ಸ್ ಗೆ ನೋಟಿಸ್ ಕೊಟ್ರು, ಅದಕ್ಕೆ ನಾನು ಕಂಪ್ಲೇಂಟ್ ಕೊಡ್ತಾ ಇದ್ದೀನಿ.
ಹೌದು, ಅವರು ಮನೆ ಕಳ್ಸೋದು ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಇದಕ್ಕೆ ಈ ತರದ ಕೇಸ್ ಇದಕ್ಕೆಲ್ಲ ಎಲ್ಲದಕ್ಕೂ ಸಪೋರ್ಟೆಡ್ ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ ಸ್ವಾಮಿ.
ಸಪೋರ್ಟೆಡ್ ಬೇಡ ಸರ್, ಅಟ್ ಲೀಸ್ಟ್ ಇದ್ರಲ್ಲಿ ಅಲಿಗೇಷನ್ಸ್ ಇದೆಯಾ?
ಓರಲ್ ಅಲಿಗೇಷನ್ಸ್
ಇದ್ರಲ್ಲಿ ಅಲಿಗೇಷನ್ಸ್ ಇದೆಯಾ?
ಅದರಲ್ಲಿ ಅರ್ಲಿಯರ್ ಕಂಪ್ಲೇಂಟ್
ದಕ್ಷಿಣೆ ಅಂತ ಒಂದು ವರ್ಡ್ ತೋರಿಸ್ಬಿಡಿ. ಅದು
ಇದ್ರ ಕೇಳಿದ್ದಾರೆ, ಇದರಲ್ಲಿ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ.
ಸಬ್ಸಿಕ್ವೆಂಟ್ ಅಲ್ಲ, ಈಗ ನೀವು ಕೈ ನನಗೆ ಕೊಟ್ಟಂತ ಕಂಪ್ಲೇಂಟ್ ಕೇಳ್ತಾ ಇದ್ದೀನಿ. 4 ಪೇಜ್ ಇದೆ.
ನಾನು ಆ ಕಂಪ್ಲೇಂಟ್ ಏನ್ ಕೊಟ್ಟೆ ಅಂತ ಹೇಳಿದ್ರೆ, ಫ್ರಮ್ 2012 to 2017 ಯಾವುದೇ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಕೇಳಿದ್ಕೋಸ್ಕರ ಅದನ್ನ ಕೊಟ್ಟಿದ್ದೀನಿ. ಈ ಕಂಪ್ಲೇಂಟ್ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ನಾವು ಕೇಳಿದಷ್ಟು ಹಣ ಕೊಡುವವರೆಗೂ ನೀ ತವರು ಮನೆಯಲ್ಲೇ ಇರು, ಹಣ ಹೊಂದಿಸಿಕೊಂಡು ಬಾ ಮನೆಗೆ, ಅಲ್ಲಿವರೆಗೂ ನಿನ್ನ ಅಮ್ಮನ ಮನೆಯಲ್ಲೇ ಇರು ಎಂದು ಮಾನಸಿಕವಾಗಿ ಹಿಂಸೆ ಕೊಟ್ಟರು.
Why that is not stated in the earlier complaint?
earlier complaint ಅಲ್ಲಿ ಬಹುಶಃ ಹೇಳಿಲ್ಲ. 2014 ಅಲ್ಲಿ ಇದರಲ್ಲಿ ಎಲ್ಲಾನು ಡೀಟೇಲ್ ಆಗಿ ಹೇಳಿದ್ದಾರೆ. ಯಾವ್ದು FIR ರಿಜಿಸ್ಟರ್ ಆಗಿದೆ ಅದರಲ್ಲಿ.
The materials on record disclose that respondent number 2 married accused number 1 on 29/1/2012. Thereafter started residing in the matrimonial house. She went to her parents' house on 4/6/2012. So hardly for about 5 months she was in the matrimonial house. It is stated that after giving birth to a child on 18/11/2012, she never returned to the matrimonial house. With this admitted fact in background, we have to consider the allegations made by the first informant.
made by respondent number 2 against the accused. It is not in dispute that since respondent number 2 had not returned to the matrimonial house, accused number 1 had issued the legal notice on 6/2/2014. Admittedly, the said notice was served on respondent number 2, but there was no reply. It is thereafter MC 79 of 2014 was filed by accused number 1 seeking divorce. The decree of divorce was granted on 12/2/2015, but it was an ex parte decree. Later, respondent number 2 filed an application seeking to recall the judgment and decree and to restore MC 79 of 2014 for fresh consideration. It is stated that the said application was allowed and the MC 79 of 2014 was retried. Now, a decree of divorce was granted with a judgment and decree dated 28/2/2025, which is said to be challenged by respondent number 2 before this court in MFA 3015 of 2025. Next part. In the meantime, on 27/3/2017, the private complaint was claimed to be filed by respondent number 2 against accused numbers 1 to 8, alleging commission of the offence punishable under section 498A of IPC and under section 3 and 4 of BP Act. The allegations are very serious in nature. ಅದು ಮೊದಲಿಂದ ಎರಡು ಡಿಸಿಷನ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಡಿಸಿಷನ್. In view of the settled position, nowadays we find filing of the complaints making serious allegations against the husband and his family members. Therefore, we have to consider such allegations in the backdrop of the conduct of the respondent number 2 and her family members. Learned counsel for respondent number 2 has produced a copy of the complaint dated 11/9/2014, said to be lodged by respondent number 2 with the Chamrajpet police station, said to be marked as Exhibit P5 before the trial court. Even though this complaint runs into 3 pages, there is not even a whisper regarding demand for dowry or additional dowry, either in the form of cash, gold, or site. There is reference to the legal notice dated 6/2/2014 issued by accused number 1 when she was in at parental house. She also refers to filing of MC 79 of 2014. There is also reference to the notice received on 4/9/2014 issued by the civil court at Mali, according to which accused number 1 had sought for a divorce. Immediately thereafter, that is on 11/9/2014, the said complaint was going to be filed, which was registered as NCR. It is pertinent to note that in the earlier complaint dated 11/9/2014, there is no reference to demand or acceptance of dowry by the accused, ill treatment given by any of the accused, The said complaint is only against accused number 1 and not against the other accused. Even then, there is no such allegations to invoke section 3 and 4 of DP Act or section 498 of A of IPC. Now the question arises as to why such serious allegations are made in the present complaint, which is filed on 27/3/2017. Obviously, it was with an intention to gain support in MC 79 of 2014, which was restored on file by recalling the ex parte judgment and decree passed on 12/2/2015. On careful perusal of the allegations made against the accused and the background under which such allegations are made, and if the same is taken into consideration along with the conduct of respondent number 2, I am of the opinion that deliberately such serious allegations are made in abuse of process of law, without there being any materials even to prima facie substantiate the same. Even though learned counsel for the respondent number 2 and learned SGP contended that a CD was produced along with the charge sheet. Time was sought for producing the said CD along with the transcription. Even after granting sufficient opportunity, even though a copy of CD is produced, and the transcription is produced, admittedly, the said conversation was not between respondent number 2 and her family members, and with any of the accused to evidence either demand or acceptance of dowry or regarding the harassment or cruelty meted to respondent number 2. Under such circumstances, I am of the opinion that there are no materials to prima facie constitute the offence, and hence the criminal proceedings is liable to be quashed. Accordingly, yes, petition is allowed.
Serial number 3 and 4, video case, TV Timmaya.
My lord, in this matter, I appear for the petitioner, my lord. This is a case, my lords, where the complaint is based on, my lords, allegations of dowry being demanded.
Who is the petitioner?
My lords, two petitioners, my lord, the father and the mother.
They are arrayed as accused number
2 and 3, A2 and A3. The husband was also, my lords, arrayed as an accused, but he passed away during the pendency of this proceedings.
He is no more now.
He's no more.
Accused number 2 is the father-in-law.
He's the father-in-law, and accused number 3 is the mother-in-law.
Police complaint or private complaint?
Private complaint, my lord. My lord, the complaint, your lordships will find.
Private complaint?
Private complaint.
PCR number?
PCR number. The charge sheet has also been filed, my lord. It is CC 54609 of 2016.
When the private complaint was filed?
Complaint was filed on 19/1/2016, my lord. Annexure B.
Dated?
19/1/2016.
Date of marriage?
The date of marriage is 21/6/2013. The two main allegations are made in the complaint.
Complaint of police complaint. This is the police
Sorry,
complaint.
it's a police complaint. I'm
And-
sorry. I'm so sorry. It's a police complaint. The two main allegations are made. One is of dowry being demanded by the husband and the in-laws. The second allegation that is made, my lord, is that it's of 354 against the father-in-law. And both, my lords, we will show, my lords, are demonstrably false. It is basically done in order to wreak vengeance. The marriage, of course, broke down. There was incompatibility between the couple, but there were no allegations of dowry. And my lord, this incident never happened. And we'll show, my lords, in fact, it is contradicted by the complaint that has been filed, which makes the reference to this section 354 incident. But in the family court petition, a divorce petition was filed by the wife. There is a reference to what happened on this date, but there's nothing about this incident of outraging the modesty of the daughter-in-law.
When divorce petition was filed?
Divorce petition was filed, my lord, on 27/8/2016, which is 7 months after the police complaint was filed.
That is against accused number 1.
Accused numbers 1, 2, and 3. Sorry, accused number 1. Filed in the family court
What
of
happened to
Mysore.
this petition? MC number?
My lord, this would have lapsed, my lords, because of the.
MC number?
This is MC number 521 of 2016.
That was pending when accused number 1 died.
It was filed before, my lord, with the.
That was pending when he died.
That was pending when he died. So that my lords effectively became infructuous. When did accused number 1 die? Accused number 1 died in 2019, my lord.
What is the allegation? Where is the charge sheet?
Well, the charge sheet we have produced. Annexure C at page 45.
ಏನಾಗಿದೆ? Respondent number 2.
Is represented by an advocate. Yes,
Yes.
But if you could just take your lordships, my lords, to the complaint. My lord, this is basically what has happened. My lord, the fact is, there are two engineers, my lord, both of them are software engineers. They got married. There was incompatibility. The reason for the incompatibility and the marital discord was, my lords, accused number 1, the husband used to live with his parents. The wife wanted the husband to separate and move to a house so that they could live separately away from the husband's parents. The relatives of the wife, the wife's husband and father and uncles, all of them also wanted them to live separately. This was the main reason for the marital discord. Then, my lords, when there was this, and at one point in time, my lords, the accused number 1 was sent by Infosys, who was his employer, to Australia. Then the wife went to Australia. The husband tried to find a job for her there because she wanted to make sure that they live separately. She did her best. She left. She was also working in Infosys. She left her job. She went there, tried to look for a job so that they could, she could find a job there. They could live separately away from the husband's parents. The husband was very clear that I'm here for a short-term assignment. I will go back and I want to live with my parents. This was the main reason for the discord. Then, my lords, there is not a single WhatsApp message, nothing at all to show that there was any kind of demand of dowry. In fact, what it shows, my lords, the evidence on record, I'll take your lordships through all of that, shows that the only reason for the incompatibility was this and some abusive language being used by the wife against the husband. The husband was a very mild-mannered boy, my lords, God-fearing. He lived with his parents. Of course, today that may be a reason for discord amongst many, that people may want to live separately, but that is not an offense. And there was some abusive language used by the wife against the husband. There is not a single evidence of demand of dowry. In fact, I'll take your lordships through the numerous contradictions that exist in terms of how much was the dowry demanded, even according to the complainant. when the dowry was paid, how much was paid, when was it paid, all of that, my lords, are contradicted by her own complaint. I'll take your lordships through, my lords, the inherent inconsistencies in the complaint itself. Lord, if I could trouble your lordships to look at page 35, annexure B.
Yes.
Lord, the complaint, my lord, which is at annexure B, starts at page 35, my lord. At page 35, my lords, after referring to the marriage, etc., at page 36, my lord, around 4-5 lines from the bottom of paragraph 1, cash of rupees 10,000. The parents of Kirtiraj insisted that the dowry amount of rupees 10 lakhs be paid before marriage. Further, my parents were told to bear the entire marriage expenses. So, my lords, the dowry that is demanded is said to be of 10 lakhs. Now, my lord, this is straight away contradicted by what is stated in the petition filed before the family court, where she says that it is not 10 lakhs, it is actually 15 lakhs. That your lordships will find at page 59 of the petition. Family court complaint, family court petition. 159, my lord. At page 159, paragraph 3, around 4 lines from the bottom of that line, the dowry that is demanded according to this petition is 15 lakhs. So, my lords, how much is the amount of dowry? There are different versions by the complainant herself.
Page number?
Page number 59, my lord. 159, I'm so sorry, 159. The divorce petition, my lords, starts at page 158, annexure T. The relevant portion your lordships will find at page 159, paragraph 3, around 4 lines from the bottom. Cash of rupees 15 lakhs has been demanded. This is the first contradiction. The next contradiction, my lords, I'm so sorry to again go back to the complaint at page 35. At page 36, my lord.
Yes.
Around 6-7 lines from the top of paragraph 2. With great difficulty, my father could make arrangement for another 2 lakhs, and on 19/6/2013, he paid the dowry amount of rupees 5 lakhs at my husband's residence at Indiranagar in the presence of my uncle Anand and so and so. With great difficulty, my father-in-law Keshavraj and mother-in-law Premaraj agreed to give some more time. Thereafter, my marriage was solemnized with Kirtiraj and so and so on 21/6/2013 at Police Bhavan, Mysore, and on the previous night, reception was held at the said venue. On the date of the marriage, my father had given dowry as agreed. So, my lords, in the police complaint, the version is 10 lakhs was the dowry, not 15. In the family petition, family court petition, it's mentioned at 15. Then in the complaint, she says that this entire 10 lakhs was paid in 2 installments. One before the date of the wedding. The second installment of 5 lakhs was paid on the eve of the wedding, which was on 26/2023. Your lordships will find that at page 37. But, my lords, kindly see the next paragraph. In the next paragraph, my lords, around 5 lines from the bottom of that page. During this period, my husband used to call me frequently and used to abuse me with foul language for not getting remaining dowry amount. My lords, in the previous paragraph, she says, I've paid the full amount. Here she says, during this period, my husband used to call me frequently.
What is the allegation against accused number 2 and 3?
My lords, essentially saying that they, my lords, were complicit in this. But against accused number 2, my lord, there is a specific instance, which is, my lords, of outraging the modesty of a woman. Your lordships will find that at page 39, second paragraph. On 12/4/2014, my lords, I just read that out. On 12/4/2014, while my husband had gone to Mantralaya and my mother-in-law had gone out, my father-in-law so-and-so, by taking advantage of my loneliness, entered into my room, started physically misbehaving with me, holding my hands and pulling me. I was in an utter state of shock and started shouting. Hearing my hue and cry, my father-in-law left me and walked out. I was totally disturbed with the pathetic and helpless situation I was in. I was so badly depressed, etc. I decided to take extreme step and consume number of painkillers which were available at home. On the early morning of next day, Malad, these dates are important. So Malad's incident, she says, happens on 12/4. Next day, 13/4, on the early morning of next day, my husband returned from Mantralaya and found me unconscious. Fearing consequences, he immediately got me admitted to CMH Hospital, Indranagar, Bangalore. In the hospital, my husband requested me not to take up the issue as it involved moral turpitude, etc., etc. Now, Malad, kindly consider this in the light of what she says in the petition before the family court. There is a completely different version at page 167. In fact, I'll read from page 166. This is the family court petition, Malaj, filed by the wife. At the bottom of page 166, paragraph M. It is submitted, petitioner spoke to her manager and got approval to work from Mysore campus and resume her work. In March 2014, respondent asked the petitioner to Bangalore not to quit her job. Petitioner joined him as the respondent had promised that he would not share personal things, etc. In April 2014, respondent planned to visit Mantralaya and made arrangements for the same. The petitioner was not taken as she had work in the office and the respondent traveled alone. The father of the respondent on that day called the aunt of the petitioner and asked her to pick her up from work and to keep her with them. That is, Malad's accused number 2 is supposed to have called the aunt of the petitioner to pick her up from work and to keep her with them. The petitioner refused to agree as she had previous experience of physical assault and came back home as usual. The parents of the respondent, Malad's in the complaint before the police, she says the mother was not there and the husband had gone to Mantralaya. Here, my lord, she says the parents of the respondent abused the petitioner for not going to her aunt's house, and this arrangement had been made by the father of the respondent only to spoil the relationship between the petitioner and respondent. On that night, the petitioner was not given any dinner and was not allowed to inside the kitchen to cook for herself. Even on the next morning, they did not allow, and the petitioner had to go to her aunt's place for food, and later on went to hospital to take an injection. On the said night also, respondent's parents shouted at the petitioner for not getting money from home and not giving a salary. The mother-in-law of the petitioner pushed the petitioner inside the room without food, and the petitioner, who was on IM injections, had to sleep without food, and the doctor had told her that if she fails to take good food, the injection will not be effective. So, man, it's completely such a serious allegation being made against the father-in-law, Malad, who's a super senior citizen, 81 years old today. And Malad, in the twilight of their lives, just because the wife is miserable with her marital life, I mean, these are the allegations she makes. And the clear contradiction she makes in the police complaint versus what she says before the family court. Same incident. In fact, Malads, I'll show from the record that Malads, this was a well-to-do family. They looked after the daughter-in-law as their own. Malads, on the contrary, Malads, instead of demanding dowry, they have given some very expensive gifts to the daughter-in-law. I'll take your lordships through all of that. At page 93, my lord, even before the wedding could take place, my lord's wedding took place in June 2013. At page 93, your lordships will find, what is that BA ticket? My lord, Annexure J, I'm so sorry. Annexure J at page 124. the accused number one, the late husband, had in fact booked tickets. Well, this was in March, 3 months before the wedding, where he was sponsoring their holiday after the wedding to London. So Malaj, there's no question of him demanding any money because he was a well-settled boy working in Infosys. Malaj making a lot of money. The family was comfortable. In fact, they were the ones who were spending on all of these things without asking any money from the wife's parents.
Both were working in Infosys.
Both were working at Infosys. At page 130, your lordships will find Malal's jewelry bills, where jewelry was bought by the wife, by the husband's family for the wife, for the wedding. At page 130. And then at page 132 and 133, Malads, they actually, to make it easy for her to commute to work, the husband's family buys her a scooter out of their funds. At page 134, your lordships will find, Malads, bank statements of the husband, where Malad, the wife goes to Infosys, Malads, as a trainee, they're only paid a stipend. So the husband at page 134 onwards, Malads, he transfers money to the wife to look after her expenses during that period when she's only paid a stipend and not a salary. Page 134, 135, etc. So, Manoj, this is not a case where there is any kind of allegation of. In fact, Manoj, the two main reasons as to why Manoj, this marriage failed. Manoj, if I could take your lordships to that. Page 146, Manoj, this is contemporaneous evidence. These are WhatsApp messages exchanged between the husband and the wife.
Page number?
Page 146, Manoj. The wife actually sends a message. Manoj, your lordship will recollect that the so-called incident of the father-in-law, Malaj, happens in April 2014. In October 2015, the wife is writing to the husband saying, thanks for being married to me for 2 years. Thanks for forgiving my mistakes in the last 2 years. Thanks for the 2 international trips sponsorship. I have made decisions based on our present state of relationship. I will anyway keep you posted on my actions of termination process. Thanks for everything. Bye, all the best. Lord, there is no allegation of dowry harassment. There is no allegation of, my lords, any kind of inappropriate behavior by the husband's father. In fact, my lords, she has used very objectionable language at page 150 against the husband. Lordships will find there's a text message sent on 15/10/2015 at 2:39 by the wife. Just get lost, that portion, my lord. I'm not reading the remaining one. And the husband responds by saying that you should be ashamed of yourself to even talk to somebody like this.
Yes, what is it?
My lords, the alleged chats which has been produced before this honorable court is not supported with section 65.
You forget about the chats.
Please, my lords. And the jewelry bills and the scooters and the bank statement.
You forget about that also. What? Come to your allegations.
Please,
against accused number 2.
Please.
Now accused number 1 is not there.
Accused number 1.
So the allegation, serious allegation against accused number 2 is regarding 354.
354. My lords, if we go through the page number 5 of the complaint, my lords, in the first paragraph itself, in the meanwhile, whenever I was alone in the kitchen or in my bedroom.
That is in the complaint.
That is in the complaint.
Why it does not find a place in the MC petition? There is a different story to tell.
My lords, maybe
not this allegation.
In total,
There is a reference to she falling sick. She was admitted to some hospital, CMH hospital, advised by the doctor. Everything is there, but not this allegation. Why strangely such a serious allegation is made against accused number 2?
My lords, the thing is, which is the complaint which has been filed earlier, my lords. for the offences punishable under section 498A and 354 of IPC, my lords. That is against accused number 123 for the alleged harassment. After this, my lords, the MC petition came to be filed. My lords, it is.
Why the version changed then?
Maybe change the
Is it the petition of the advocate or the respondent number 2?
My lords, whatever the client will say, that will be drafted by an advocate.
Then naturally it is the version of respondent number 2. What justification you can have?
Both the proceedings will go differently, my lords, and this will
Maybe,
be.
but the version of respondent number 2 cannot be two different versions. No, there cannot be any that too when such serious allegations are made. She is accountable for that. She is responsible.
Whatever.
And according to him, she is also a software engineer. She is not a rustic villager
She is educated.
to make such allegations.
My lords, but the trauma that has been suffered when she was,
No.
she had stayed at her matrimonial.
Now the
house.
charge sheet is filed. Is there any
Charge sheet
material
has
to support that such contentions? Regarding dowry also, there are two contradictory statements.
My lords, if we go through the charge sheet amendments, my lord, whatever the submissions that has been made by the senior counsel, my lords, that my lords, even if or otherwise, if we go through the submissions that has been made, my lords, that amount transferred, that has been transferred out of love and affection, my lords, 1 point.
See,
Tax, my lords.
both are software engineers.
Please.
Why she will give 600 grams of gold, 4 kgs of silver, 2 lakhs rupees worth household articles, 5 lakh rupees cash, and additional demand for 5 lakhs. As per the MC, there was a demand for 15 lakhs.
My lords, there would be a
Why
slight
any girl will accept that? That to an educated girl.
bit improvisation may be there, my lords, but the basic allegation.
Big
what
tell,
we-
madam, with entire deviation from the earlier allegations. Complete deviation.
Lords, as per charge sheet, allegation against husband accused number 1 is there. my
It is nothing but the allegations for the sake of making allegations. How can it be accepted?
Sole testimony of the victim that has to be taken into consideration.
No, that gone are the days. You have to believe the version of the victim. Gone are the days. We are seeing some sorry state of affairs. There must be some justification. When such serious allegations are made, what will be the natural reaction by the wife? If the father-in-law misbehaves, what will be the natural reaction?
She should have gone to the police station. She should have first intimated to her husband.
Huh? Where is that?
That is not.
Husband was away. Nowadays, everyone will have the phone.
This is the 2014.
The software engineers, they will be very quick in sending mails, WhatsApp messages. That will be spontaneous reaction, right?
But the WhatsApp chat which has been produced before this honorable court is.
I am not
suitable-
consider, for your information, I am not taking into consideration those chats. No,
Only for otherwise.
but the contradictory stand taken by respondent number 2, one filing the complaint and the other while filing the MC petition. There cannot be any explanation.
That I do admit, my lords, but that is the completely 2 different proceedings, my lords.
And 2 different versions, except saying accused number 1 had been to Mantralaya on which date? That is
12th of April
12th
2014.
of April 2014. And the other all incidents have changed. According to complaint, even the mother-in-law was not there, but as per MC petition, she was there. She also abused her. She was not provided with food. She was locked up inside. Every sort of allegations are made. Later, she comes to that, I was admitted to hospital. Doctor advised to take food. Where are the material? Is there any medical records? Then any history is given before the doctor saying that the father-in-law misbehaved with me, so I consumed something.
No medical records.
No, then how it is to be said there are prima facie materials. It is easy to make allegation against anybody.
It can't be disputed that she is a married lady, my lord.
Correct.
She lived with her in-laws.
Yes, that is what I am saying. The married lady will be very responsible and she will be very spontaneous in her action.
I leave it to this honorable court.
No, no justification. So, the petitioners being accused number 1 and 2 and 3. In the CC 54609 of 2016 on the file of the learned 10th additional chief metropolitan magistrate Nehal Bengaluru, registered for the offence punishable under section 498A 354 of IPC under section 3 and 4 of DP Act. Heard so and so affirmative. Advocate for respondent number 2 remain absent. This argument is taken as nil. Affirmative. It is the contention of respondent number 2 that she married accused number 1 on 21/6/2013. The complaint was going to be filed on 19/1/2016. After investigation, charge sheet came to be filed. As per the allegations made in the first information, there was demand for a dowry of rupees 10 lakh, out of which rupees 5 lakh was paid, 600 grams of gold ornaments, 4 kgs of silver, 2 lakhs rupees worth household articles were given at the time of marriage. It is also alleged that accused number 2, being the father-in-law, misbehaved with her by holding her hand when her husband and mother-in-law, that is accused number 1 and 3, were away at Mantralaya, and thereby he committed the offence punishable under section 354 of IPC. Next. Learned counsel for the petitioner has produced the copy of the petition filed by respondent number 2 before the family court at Mysore, registered in MC 521 of 2016 under section 13(1) bracket again bracket small 1A of Hindu Marriage Act, seeking divorce. The allegations of this petition was filed by respondent number 2 seeking divorce on 27/8/2016, whereas the complaint is dated 19/1/2016. Even though there is a reference to the incident that had occurred during March-April 2014, when 14, stating that accused number 1 was away at Mantralaya. It is stated that accused number 2 and 3 were in the house and they abused her in filthy language by compelling her to go to her aunt's place. She was not provided with food and she was made to starve. Thereafter, she went to CMH Hospital, Indiranagar on 13/4/2014. In the first information dated 21/6/2013, first information dated 19/1/2016, entirely different version is given that accused number 1 alone had been to Mantralaya. Accused number 1 and 3 have been to Mantralaya. She was all alone in the house along with accused number 2. When he held her hand and misbehaved, tried to outrage her modesty.
Thereafter, she went to hospital, CMH hospital, when accused number 1 returned from Mantralaya and found her unconscious. Unfortunately, no medical records were produced in support of the contention. Next para. It is stated that both accused number 1 and respondent number 2 are software engineers working at Infosys at the time of marriage. During the pendency of this petition, accused number 1 died and the petition filed by him stood abated. Under such circumstances, the allegations made against accused number 2 and 3 are taken into consideration. Even though serious allegations are made against accused number 2 regarding commission of the offense under section 354 of IPC, the same is contradicted by respondent number 2 by narrating a different story while filing the divorce petition before the family court. Even demand and acceptance of dowry is not supported by any prima facie materials. When respondent number 2 is a qualified software engineer working in Infosys, I do not find any reason for her to accept the demand made by the accused for payment of dowry. Even with regard to demand and acceptance of dowry, there are inconsistent versions making such allegations to remain only as an allegation without any prima facie materials. Moreover, there is inordinate delay in lodging the complaint, which is also not explained. In the result, I am of the opinion that there are no prima facie materials to support the allegations made in the first information or in the charge sheet, which prima facie discloses that the same are made with an intention to have a ground for prosecuting the petitioners before a criminal court. It is definitely an abuse of process of law, hence the proceedings are liable to be permitted. Petition is allowed.
Deep refreshments.
Well, Lord, I request. Last time I was ready, my other side was not ready.
So today you are not ready.
Not ready. Sorry.
Internally,
No.
Then
I'm not. It's not that. I am
12.
any next week. Any
Serial number 12. It's time.
Serial number 8. I am for the petitioner. List number 2, madam. His service of senior counsel is relative.
For the petitioner, praise time.
Relatives express.
Order sheet dated so and so reads as in spite of that. Next.
Your Lordship, list 2, serial number 5, Your Lordship. Request for a short accommodation, Your Lordship.
Praise time.
And Ismail Zabiullah's name may be removed, Your Lordship. I have given NOC.
Yaru, now who is representing?
It's Chand Pasha, Your Lordship.
Chand Pasha. Remove the name of signature.
Apologies. Intermod, there is an intermod.
Yes.
Please.
Court officer, madam. Court officer, madam. Interim order ಇದೆ. List 2, 5. Extend.
Serial number 2, list number 8. List number 2.
5 ಗಂಟೆಗೆ ಮೀಟಿಂಗ್ ಇದೆಯಲ್ಲ.
ನೀವ್ ಇಟ್ಕೊಳ್ಳಿ ಪಕ್ಕದಲ್ಲೇ.
ವಿಕ್ಸ್ ಹಾಕೊಂಡಿದ್ದೀನಿ.
ಫಿಕ್ಸ್ ಹಾಕೊಳ್ಳಿ, ಇನ್ನೊಂದು ಇಟ್ಕೊಳ್ಳಿ, ನೀರು ಸ್ವಲ್ಪ ಇಟ್ಕೊಳ್ಳಿ.
ಆಮೇಲೆ ಬಿದೋಗ್ಬಿಡ್ಬೇಕು ಅದು. ಮನೇಲಿ ಎಲ್ರಿಗೂ ಹುಷಾರಿಲ್ಲ. ಮಗಳಿಗೆ ಮತ್ತೆ ಜ್ವರ ಅಂತೆ, ನಮಗೆ ಯಾವಾಗ ಜ್ವರ, ನಾಳೆ ಭವಿಷ್ಯ ಗೊತ್ತಿಲ್ಲ. ನನಗೂ ಜ್ವರನೇ ಇದೆ, ಆದ್ರೂ ಬೇಕಲ್ಲ.
ಪಿಲ್ಲರ್ ಹತ್ರ ನಿಲ್ತಾ ಇದ್ದೀರಾ ಮನೆಗೆ, ಒಬ್ರು ನಿಂತ್ರೆ ಇನ್ನೊಬ್ರು
ಬೇಕಲ್ಲ ರಜೆಗಳು. ಈಗಲೇ ಸ್ಟಾರ್ಟಿಂಗ್ ಅಲ್ಲಿ ಹಾಕೊಂಡು ಖಾಲಿ ಮಾಡ್ಬಿಟ್ರೆ ಅಂತ ಒದ್ದಾಡ್ಕೊಂಡು ಬರೋದು. ಬೇಕರಿಂದ ಫೋನು, ಜ್ವರ ಬಂದಿದೆ ಅವಳಿಗೆ.
ಅದು 2 ದಿನ ಇರುತ್ತೆ, ಕಂಟಿನ್ಯೂಸ್ ಸಿರಪ್ ಹಾಕ್ತಾ ಇರ್ಬೇಕು. ಅದು 6 hours ಅದೇನೋ ಇರುತ್ತೆ ಅದಕ್ಕೆ ಡೋಸೇಜ್.
ನೀವು ಯಾರಿಗೆ ಇದೆ ರೆಡಿನಾ? ಓ ಅದೇನಾ, ಆಯ್ತಾಯ್ತು. ಇದೆ ಇದೆ.
ಡೋಸೇಜ್ ಹೇಳಿರ್ತಾನಲ್ಲ, ಜ್ವರದ ಮಾತ್ರೆ ಅಥವಾ ಸಿರಪ್ ಕೊಟ್ಟಿರ್ತಾನಲ್ಲ, ಡೋಸೇಜ್ ಹೇಳಿರ್ತಾನೆ. ಆಫ್ಟರ್ 5 or 6 hours ನೆಕ್ಸ್ಟ್ ಕುಡಿ ಅಂತ. ಅದು 2 days ಅಂತ ಗ್ಯಾರಂಟಿ ಅವ್ನು ಹೇಳಿದ ಟೈಮ್ಗೆ ಹಾಕಬೇಕು. ಅಂಡ್ ನೆಕ್ಸ್ಟ್ 2 days ಆದ್ಮೇಲೆ ಆ ಟೈಮ್ ಬಿಟ್ಟು ನಿಮ್ಗೆ ಜ್ವರ ಬರಲ್ಲ, ಅವಾಗ ಅದು ನಿಂತಿದೆ ಅಂತ. ಫಸ್ಟ್ 2 days ಇರುತ್ತೆ ಅದು, ಅಷ್ಟ್ರಲ್ಲಿ ಅದನ್ನ ಹಾಕ್ಕೊಡ್ಬೇಕು. ಆ ಟೈಮ್ ಅಷ್ಟೊತ್ತಿಗೆ ಹಾಕಿದ್ರೆ ಅದು ನೆಕ್ಸ್ಟ್ 3 hours ಅದು ಎಷ್ಟು ಕೊಡ್ತಾನಲ್ಲ ಡೋಸೇಜ್ ಅಲ್ಲಿ ತನಕ ತಡೆಯುತ್ತೆ. ಫಸ್ಟ್ 2 ದಿವಸ ಅಥವಾ 3 ದಿವಸ ಮ್ಯಾಕ್ಸಿಮಮ್ ಅಂತ. 3ನೇ ದಿವಸ ನೀವು ಒಂಚೂರು ಲೇಟ್ ಮಾಡಿ ನೋಡಿ ಹಾಕಕ್ಕೆ, ಅಷ್ಟೊತ್ತಿಗೆ ಅದು ಬರಲ್ಲ ಆ ಟೈಮಿಗೆ.
ಕಂಟಿನ್ಯೂ ಮಾಡಿ. 4 ಗಂಟೆ ಒಳಗೆ ಮುಗಿಸ್ತೀನಿ.
My lordship's kind permission, my lords.
Yes.
May I make a mention, my lords? My lords, in list 2, serial number 3, my lords, which was disposed of, my lords, just before lunch. I am appearing on behalf of respondent number 2, my lords. My lords, the counsel on record is no more a part of the office. My lords, on instructions, my lords, I am told, my lords, my absence was recorded.
It's already disposed of, sir.
Please, my lords, my presence may be recorded, my lords. That's all I'm requesting, my lords. It may be
Sir?
disposed of, please, my lords.
Which serial number, sir? Which list?
List
Serial
2,
number?
list 2, serial number 3. Serial number 4. I am sorry, my lord. Serial number 4. My colleague, Mr. Timaya, my lords, is no more part of the office. He has, my lords, left the office. Please.
What is your name?
Rajat, my lords. Rajat.
Learned Counsel Shri Rajat represents respondent number 2 and submits that Shri K.V. Timaya is no more. His office is directed to delete the name of Shri K.V. Timaya and show the name of so and so.
Please, my lords. My
Yes.
apologies, my lords. Grateful.
Yes.
List 2, serial number 6, Kamaluddin.
ಪಾಸ್ ಓವರ್ ಇಲ್ಲ ಸರ್, ಮಾಡಬೇಕು ಕೂಡಲೇ. ತಗೊಳ್ಳಿ ಇಲ್ಲ ಸರ್, ಪಾಸ್ ಓವರ್ ಇಲ್ಲ. ಈಗ ಲಿಸ್ಟ್ ಮುಗಿಸ್ಬೇಕು, ಹೋಗ್ಬೇಕು ನಾವು. ಕೌನ್ಸಿಲ್ ಫಾರ್ ದ ಪಿಟಿಷನರ್ ವೇಸ್ಟ್ ಟೈಮ್. ನೆಕ್ಸ್ಟ್ ಡೇಟ್.
ಎ ಹನುಮಂತಪ್ಪ, ಜೀವನ್ ಜ್ಯೋತಿ ಅರಳಿಗಿ, ಬಿ ಮುರಳೀಧರ್, ಬಿ ಪಾಟೀಲ್.
7.
Charge sheet is already filed. ಅದೇನದು? ಇಲ್ಲ ರೀ, whether it is filed before the learned magistrate. It is to be submitted before the learned magistrate, sir. It is to be filed before the learned magistrate, not before this court. Follow the procedure. Learned, you are for? Learned counsel for respondent number 6 submits that the investigation is almost completed and sanction is awaited. Once it is received, the final report will be submitted to the jurisdictional magistrate. Yes, I ಮತ್ತೆ ಏನು ನೀವು ಹಾಗೆ ಹೊರಟು ಇನ್ನೂ ಸಬ್ಮಿಟ್ ಮಾಡಿಲ್ಲ ಅವರು? ಮಾಡಿಲ್ಲ ಅಂದ್ಮೇಲೆ ಅದು ನೀವು ಏನ್ ಮಾಡ್ತೀರೋ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಈ ಪಿಟಿಷನ್ ಏನ್ ಮಾಡ್ಬೇಕು ಕೇಳ್ತಾ ಇದ್ದೀನಿ. ಯಾಕೆ ಯಾಕೆ ಸರ್? ನೌ ಯು ಆರ್ ಚಾಲೆಂಜಿಂಗ್ ದಿ FIR. ಗೋ ಹೆಡ್ ವಿತ್ ದಟ್. ನೋ ದೆನ್ ನಾಟ್ ಪ್ರೆಸ್ ಮಾಡಿ. ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ರೆ ಮಾಡಿ, ಅದರ್ವೈಸ್ ನಾನು ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತೀನಿ ಅಷ್ಟೇ. The submission is placed on the petitioner submits that if charge sheet is filed, he would like to challenge the charge sheet. Next, the petition is filed seeking to quash the FIR registered in crime number 3 of 2021. Since the petitioner is since the petitioner is not willing to prosecute this petition is dismissed. Yes, next.
Number 8, Arjun. 9, Radhika M. Jayashree Narasimhan.
Liberty may be given, my lord. I will challenge the charge sheet if they filed. I am ready, my lord. I will proceed with the
Sir,
case.
you must know how to make submission before the court.
Charge sheet file ಮಾಡ್ತಿದ್ದಂತ sir.
Mindful of your body language and
Please,
submissions.
Please.
15 ದಿನ ಕಾಯಿರಿ ಅಂದ್ರೆ ಏನು ಪೇ ಮಾಡಿ ಕೂರಿಸಿದಿರ ಇಲ್ಲಿ?
ಅವ್ರು ಸಬ್ಮಿಷನ್ ಮಾಡಿ ಲಾಸ್ಟ್ ಟೈಮ್ ಐ ಆಮ್ ರೆಡಿ.
Whatever may be the submission, you are an advocate on record.
They said, my lord,
you must know how the submissions are to be made. ಏನಂತ ತಿಳ್ಕೊಂಡಿದ್ದೀರಿ ಇಲ್ಲಿ?
2 days ಅಲ್ಲ ನಾಟ್ ಚಾಲೆಂಜ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀನಿ ಸರ್. Maybe taken up after 2 days.
ಏನು ದಾದಾಗಿರಿನಾ ಇಲ್ಲಿ?
ದಾದಾಗಿರಿ
15 ದಿವಸ ಬಿಟ್ಟು ತಗೊಳ್ಳಿ ನೋಡೋಣ.
Charge sheet file ಮಾಡಿ.
I should wait.
I'm sorry, my lord, that makes submission, my lord. Only intention is, my lord, charge sheet file ಮಾಡ್ದೆ ಅಂತ ಹೇಳಿ.
First court hall etiquettes ಕಲ್ತ್ಕೊಳ್ಳಿ.
Please, my lord.
ಆಮೇಲೆ ಅಡ್ವೊಕೇಸಿ ಮಾಡೋದು.
2 days I will make submission on merits itself.
ಏನೋ ಕಾರಿಡಾರ್ ನಲ್ಲಿ ಮಾತಾಡ್ದಾಗಲ್ಲ.
2 days I will.
ಅದನ್ನ ತೆಗೀರಿ. Counsel for the petitioner, praise time. ಇದು next ಇದೆ.
Serial number 9, Radhika M. Jayashree Narasimhan.
Lordship, I am for the petitioner. This matter was heard wholly and it was reserved for orders. Amele tirga it is released. I'll make.
Heard by me?
No.
Then?
ಅಲ್ಲ ಹೇಳಿದ್ದು ಇದು ಇಲ್ಲ ಹೇಳಿದ್ದು ಇದು it was reserved and again it's come. Your Lordship, I am for the petitioner. The yes. And the charge sheet is being placed.
Now charge sheet is filed.
Your Lordship, let me make my submissions, then my learned friend can make. Your Lordship, this petitioner, the petitioner is, and the respondent met on a Bumble app, dating app.
What is that you are challenging here?
Your Lordship, no, FIR, I challenged the FIR and then.
According to him, final report is already.
Yes, Your Lordship, and before that, there was an report, submitted by the direction was given by this court to file the report before this honorable court. And in that report, it was clearly mentioned that they both know each other and then.
I am not on merits of the case.
Yes, Your Lordship.
Now his submission is the investigation is completed, final report is filed.
Yes, it is already placed before the.
Still you are arguing the matter.
Yes, it is,
Go ahead.
it is already placed, your lordship, and now the section is under section 417 and 420 of IPC.
I don't know. The petition is not amended.
Yes, your lordship,
Yes,
it's not
proceed.
amended, but it was,
Proceed.
may I be allowed to amend the petition, your lordship?
I don't know. You are the master of your
No,
case.
no,
You
that-
must
that-
know what is to be done.
Now, after that, it was heard, your lordship, I had given a citation where in.
Sorry, madam, I never heard this matter. Don't repeat the same thing. I never heard this matter.
Yes, your lordship.
If you are ready, I will take up the matter.
Yes, I'm ready.
Yes,
Your,
proceed.
your lordship, I've already filed a synopsis of this cases, your lordship.
Yes.
Synopsis.
Who are the petitioners?
I'm the petition, only one single petitioner, Ashok Garg.
What are the offense?
Offense is under section 4, it's a charge, the FIR is 420 and 406, but the charge sheet is filed and now the section is
I am not
470.
taking into consideration the charge sheet because the prayer is only to pass the FIR.
Yes, your lordship.
Yes.
The.
420 and 406.
Yes, your lordship.
Yes.
These petitioners met on a Bumble app. On
tell me what
in
is
the
the
month of 2019 February, your lordship, and then they had switched to the WhatsApp chats and they befriended the WhatsApp chat. In the WhatsApp chat, I mean on 30/12/2019, which was produced by me, in that it's clearly stated that I hope I mean on 19/12/2019, it clearly states that I remember you said you are married. Then later on, the discussion goes on, and then they meet together in the Bangalore. She invites him to Bangalore, and then they meet in the Bangalore, and then they I mean stay in the hotel for 3 days. And then after that only again the nowhere the marriage topic is come. Only later stage, after they go to Udaipur and all and stay together, then at the later stage the marriage issues come. But she has the knowledge that he is married, but in the objections filed by them, she mentions that she had no knowledge, and I mean she came to know only later, and by then if you peruse her complaint itself, it's your lordship, the complaint in page number, sorry, complaint in page number 12, the last line, last but least, when I confronted him, accepted that he is married and has a son. Even after this, I tried calling him, but he refused to answer my calls. So, because he was not ready to, I mean, answering the call and all these things, because of that, and they were in relation from 2019 to 21, sorry, your lordship, more than 2 years. Also, there is a report court filed filed before this honorable court after going through the WhatsApp chats. That was filed on 31/1/2024. The report is before you.
Yes.
And this court had ordered directions to produce the documents before the investigation officer and to submit the final report. On 31/1/2024, the investigation report was filed in which it clearly states that it was a consensual sex and they knew each other about, each other's status, and then they had entered with willfully. And this honorable court again gave a direction to the final report. During that final report was still pending, they had made a submission. It is like as the same offense, 420 and 406. But when they filed the charge sheet, it was 417 and section 417 and 420. Your Lordship. 420 does not attract here, and 417 she already had a knowledge, and there was no inception of fraudulent or anything. And both, she's a scientist by profession, Your Lordship.
Did you say that she was having knowledge?
Yeah, she herself in the chat, which I have already produced, Your Lordship.
Where is it?
The chat, it's a part of the chat sheet.
ಎಲ್ಲಿದೆ ಅಂತ ಹೇಳ್ಬೇಕು.
ಅಲ್ಲ
ಯಾವ
ಕೊಟ್ಟಿ
page?
ಅಲ್ಲ ಅದು ಆಲ್ರೆಡಿ ಒಂದು
Charge sheet. Yes, page number.
Your Lordship. Then my copy I had given, Your Lordship, for that the entire my copy, and before that I have given extract of the charge sheet. It's running around 6,000 page, Your Lordship, the charge sheet. Sorry, the WhatsApp chat. In that, I had extracted few, and the other side had extracted few and given. Now the entire charge sheet was my copy, which I had given the.
Now, what is to be done by me?
Your Lordship,
What
there's
I
another
have to do?
extract.
I have
of
to search for it?
No, Your Lordship,
Then-
I've given the extract of the charge sheet, this WhatsApp
Where
chat.
is it?
I've already produced before the court, Your Lordship. Idralli. 6,000 pages, Your Lordship. 6,000 pages. I'll show you. Itra ide. In page number 9. I've already produced that. This is part of the charge sheet, very much part of the charge sheet. I've marked already in the charge sheet. It's already marked and given, Your Lordship. Part of the charge sheet. That she's already having the knowledge that he's married. ಆ ಥರ ಅದೊಂದು ಕೊಟ್ಟಿದ್ದೀನಿ.
Pass over the matter. Find out.
Much.
Serial number 10 for the party, Basavaj Banor.
May I request your Lordship to kindly take 10.1 first. But the second respondent filed the first information, which your Lordships find.
Who are the petitioners in this?
Not they're the accused, 1 to 4.
In
That's in this- in the-
317?
But may I request, but 10.1 may kindly be taken first.
No, first you tell me, who are the petitioners in
But there are the accused lots
317?
in this crime. Accused in crime number.
No, what is their status as accused? Accused number 1,
Yes.
2, 3, 4, how many
Yes,
accused
there,
are there?
there are 1 to 4. Accused numbers 1 to 4. The Lordships find their rank, my lords, that
In all, how many accused are there?
there are 5 accused. There are in this 1117, there are 5 accused. 4 have approached this honorable court in this petition. I think
They are accused number 1 to 4?
1 to 4.
And who are these 11, 22?
They are same accused 1 to 4 in crime number 0276 bar 2021.
0?
276 bar 2021 dated 7/11/2021.
And what about this 1117?
1117, the crime number is 0275/2021, dated same 7/11/2021.
There were two complaints
There are two separate complaints, two separate complainants also,
against the same accused.
same accused.
Accused are same.
Accused are same. Only in 1117, there's one additional accused.
What are the offense?
But offense alleged are section 406, 418 and 420 in 0276, and in 0275, 418, 406 and 420.
In both the cases, 406,
Yes, yes.
418,
That-
420.
May I just state the facts notes as obtained from the first information itself?
Now, final report is not filed.
No, not. Annexure B, page 16 is the first information given. Your lordships have a 1117. May I request 1122, my lord. Facts are simple and I'll just.
Yes.
First, annexure B at page 16 is the first information given by the second respondent. Lord, it states that he entered into an agreement to purchase a flat on 4/6/2019. That flat number he indicates, my lords, as D803.
There was an agreement to sell dated
4/6/2019 between the company of which the accused are the directors in favor of the complainant. Your lordships find that agreement it is dated
What is the
21/7.
total consideration.
21/7/2018, lords. Your lordships find that agreement. I'm sorry. There's a.
Date of agreement.
That is 4/6/2019. 4/6/2019.
What is the total consideration amount? 67,000, 67 lakhs.
In respect of flat number 8, D803. Now the allegation is
ಯಾಕೆ ಯಾರಿಗೂ ಫ್ಯಾಕ್ಟ್ಸ್ ಬಗ್ಗೆನೇ ಗೊತ್ತಿರಲಿಲ್ಲ ಈಗ ಬಂದ್ಮೇಲೆ ಅದನ್ನ ನೋಡ್ಬೋದು ಇದನ್ನ ನೋಡ್ಬೋದು. What is this?
I missed one page where I had made notes.
Date of agreement ಗೊತ್ತಿಲ್ಲ, total consideration ಗೊತ್ತಿಲ್ಲ, what is the advance amount ಗೊತ್ತಿಲ್ಲ, what is the allegation ಗೊತ್ತಿಲ್ಲ.
One second, I'll just.
That is in 1122 he is referring to. Yes, what is the total consideration? 67 out of which only 1 lakh.
42,97,550 was paid as advance payment.
Under the agreement to sell?
Yes, 15/6/2019 is agreement.
Annexure D, my lord. Annexure D, page 20.
Total advance paid 42,97,550 under the agreement through checks. All through checks. A single check or different checks? Yes. Then what happened?
The allegation is
that I entered into agreement to sell 50 flats in favor of Rajakumari.
This 1112 refers to flat number 808.
D803.
Yes. What about this one? 1117.
So that is in respect.
Flat number C806.
I'll just complete the facts plots in the 10.1 matter. Idu admele, the allegation is that the company which had executed the agreement in favor of the second respondent entered into another agreement to sell in favor of Rajakumari in respect of 50 flats.
Petitioners.
Petitioners and the petitioners company.
Company is represented by the petitioners.
Yeah, one of the petitioners. Yes.
Are you disputing that they are the directors?
No, I'm not disputing the directors. The allegation is that 50 flats are sold under the agreement dated 27/2/2019, Annexure E. Those 50 flats are the consideration shown in that document E, 8.5 crores for 50 flats.
Sir, we are not concerned
No,
about
the reason is
other
this,
flats.
that
Only D803, C806.
No, I'm making submission regarding D803. That flat is not part of the agreement. That was a security agreement actually, because they had raised the loan from her, 8.5 crores for the purpose of the project. And subsequently that has been cancelled also. It's also part of the record. So that second agreement in favor of Rajkumari was because she had loaned 8.5 crores to the developers as a security 50 flats.
Let me consider your defense later. First, I should understand.
I'm giving the facts only. I'm giving the facts only.
ನೀವು ಕಂಪ್ಲೇಂಟ್ ಓದಲ್ಲ, ನನಗೆ ಓದ್ಲಿಕ್ಕೆ
ಇಲ್ಲ
ಬಿಡಲ್ಲ,
ಸಾರಿ ಐ ಆಮ್ ಸಾರಿ,
ಅವ್ರಿಗೆ ಹೇಳಲಿಕ್ಕೂ ಬಿಡಲ್ಲ.
ಇಲ್ಲ
ಇದು
ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಅಷ್ಟೇ ಹೇಳಿದ್ದಾರೆ, ಇವರು ಮತ್ತೊಂದು ಅಗ್ರಿಮೆಂಟ್ ಮಾಡಿ ನಮ್ಮ ಫ್ಲಾಟ್ ನ ಮಾರಿದ್ದಾರೆ ಅವರಿಗೆ, ಅದಕ್ಕೆ ಇದು ಮೋಸ ಆಗಿದೆ ಅಂತ ಹೇಳಿ.
ಸಬ್ಸಿಕ್ವೆಂಟ್ ಅಗ್ರಿಮೆಂಟ್ ಡೇಟ್ ಎಷ್ಟು?
ಅದು ಅವ್ರ ಪ್ರಕಾರ 27/6/2019. ಅದು ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಬಂದಿಲ್ಲ ಅದಷ್ಟೇ, ಬಟ್ ಅದು ಇರೋದಷ್ಟೇ ಫ್ಲಾಟ್ ಇನ್ನೊಬ್ರಿಗೆ ಮಾರಿದ್ದಾರೆ ಅಂತ.
That was executed in favor of?
In favor of Rajakumari, who is the fifth accused in the other complaint.
Have you collected the advance amount?
ಅಲ್ಲಿ ಟೋಟಲ್ ಕನ್ಸಿಡರ್ 8.5 ಕೋಟಿ ಅಂತ ಅಷ್ಟೇ.
What is the advance amount received?
ಅಲ್ಲ, ಅದರಲ್ಲಿ 8.5 ಕೋಟಿ ಅವರು ಇನ್ವೆಸ್ಟ್ಮೆಂಟ್ ಅಂತ ಕೊಟ್ಟಿದ್ದಷ್ಟೇ. ಅದಕ್ಕೆ 50 ಫ್ಲಾಟ್ಗಳದ್ದು ಅವ್ರಿಗೆ ನಾವು ನಂಬರ್ ಹಾಕಿ.
ಆಯ್ತು ಬಿಡಿ ಸರ್. What is the difference? Why it is to be questioned?
Only that was the
ನ್ಯೂ ಕಮರ್ ಹಾಗೆ ಮಾಡ್ತಿರಲ್ಲ, ಏನ್ ಮಾಡ್ಬೇಕು ಪಾಟೀಲ್?
ಇಲ್ಲ,
ಒಂದು ಸಿಂಪಲ್ ಫ್ಯಾಕ್ಟ್ಸ್ ಹೇಳಲಿಕ್ಕೆ ಗೊತ್ತಾಗಲ್ಲ ಅಂತಂದ್ರೆ ಇದರಲ್ಲಿ ಅಡ್ವೊಕೇಸಿ ಇದು
ಅಲ್ಲ. ಇದರಲ್ಲಿ
ಬಂದಾಗಿಂದ ನೋಡ್ತಾ ಇದ್ದೀನಿ ಸೇಮ್ ಥಿಂಗ್, ಬ್ಲಾಂಕ್ ಫ್ಯಾಕ್ಟ್ಸ್ ಏನು ಗೊತ್ತಿಲ್ಲ.
The submission
ಹೇಳಿದ್ರೆ ಏನೇನೋ ಹೇಳೋದು.
ಇದರಲ್ಲಿ
we have to tolerate all these things.
The agreement itself shows that it was not intended to be a transaction of sale. That's the contents. And our ಪ್ರಕಾರ ನಮ್ಮ ಫ್ಲಾಟ್ ನು ಸೇರಿಸಿ ಇವರು ಅಗ್ರಿಮೆಂಟ್ ಇನ್ನೊಬ್ರು ಮಾಡ್ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ. ಅಂಡ್ ಒಂದೇ ಸಬ್ಮಿಷನ್, ಈ ಅಗ್ರಿಮೆಂಟ್ ಅಲ್ಲಿ ಇವ್ರ ಫ್ಲಾಟ್ ಇಲ್ಲ, D803 ಇಲ್ಲ. So that was, and it was only for the purpose of investment. Subsequently, the money is paid back to her and it is cancelled. That is the material which is placed by the petitioners before the Honorable Court in this case.
If that was not the subject matter, where is the question of cancelling the agreement?
50 ಫ್ಲಾಟ್ ಬೇರೆ 50 ಫ್ಲಾಟಿಗೆ ಅದರಲ್ಲಿ ಅದು ಎರಡನೇ ಮ್ಯಾಟರ್ ಅದು ತೋರಿಸ್ತೇನೆ ತಮ್ಗೆ.
And this consideration amount 42,97,000 was returned.
Now, in fact, that subsequent agreement has been cancelled and it is with the developers for it is free for their final transaction. They are aware of this position, in fact. that cancellation.
Must be aware.
No, I'm only making
He
submission.
is not writing the order.
No.
I have to write it.
The submission is only this. Second agreement was only as a security for the person who had loaned money, and based on that, they suspected our bona fide and filed this first information, and it is registered. Now, thereafter, that second agreement is cancelled and the flat is available for transaction. But this particular D803 is not one of the apartments which is the subject matter of the second agreement in favor of Rajakumari in this case. Therefore, their whatever apprehension they have stated here is, shown by the registered documents that it is not founded based on the documents. So therefore, my request is that D803 was never a flat which was subject matter of a second transaction. What is alleged here? Money is with the developers, they are free to, take it. Because the FIR is registered on these facts and these are the registered documents, not this petition is filed. There is no criminality, my lord, here, for a simple reason that D803 is not subject matter of second agreement. Insofar as the case of case in 10.1. Kindly see the list of apartments which are offered as security in the second agreement. You should find that list at page 51 and also in the schedule. Schedule of the flat numbers is available at page 63, schedule C property null. In the second agreement. Second agreement is at annexure E, page 37. It starts at page 37. And the schedule, subject matter of that agreement, which was only meant to give as a security, where 8.5 crores were borrowed by the developers for the purpose of the project. And that has been refunded, and the cancellation agreement also is registered subsequently.
Why it is styled as agreement to sell, agreement of sale?
ಅದು ಐ ಥಿಂಕ್ ದಿ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಆಗುವಾಗ ಅವರು ಹೇಳಿರ್ಬೇಕು, ಹಂಗೆ ಬರೀ ಮಾರ್ಟ್ಗೇಜ್ ಗಿಟ್ಗೇಜು ಅಂತಂದ್ರೆ ಅದು ದಟ್ ಮೇ ನಾಟ್ ಹೆಲ್ಪ್ ಅಂತ ಹೇಳಿ ಮಾಡಿ ಶೆಡ್ಯೂಲ್ ಸಿ
According to it is a mortgage deed.
Ostensible mortgage deed. It is an ostensible mortgage deed, and that has been redeemed also now by another registered, subsequent registered document, which I have produced. At annexure F, page 75.
This agreement is already cancelled.
Yes. Page 75, annexure F, on 17/12/2021. Just to make the facts clear, in the schedule which was of the second agreement, page 63.
Why you are saying that it is only a security?
Because 50 ಫ್ಲಾಟ್ಗೆ 8.5 ಕೋಟಿ ಮಾತ್ರ ಹೇಳಿದೆ. ಇಲ್ಲಿ ಇವ್ರ ಫ್ಲಾಟ್ ಒಂದೇ ಫ್ಲಾಟ್ಗೆನೆ 60 ಲಕ್ಷ ಇದೆ.
ಅಲ್ಲ, whether your submission is supported by any of the terms of the agreement?
ಟರ್ಮ್ಸ್ ಅಂತಂದ್ರೆ ಇದು ಅಗ್ರಿಮೆಂಟ್ ಟು ಸೆಲ್ ಅಂತ ಮಾಡಿ ಬರೀ 8.5 ಕೋಟಿ ತಗೊಂಡಿದ್ದಾರೆ 50 ಫ್ಲಾಟ್ಗೆ. ಆಮೇಲೆ ಅದು ದುಡ್ಡು ವಾಪಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
We have to presume.
Ostensible mortgage ಅಂತ ಕೇಳಿದ್ನ. It's an ostensible mortgage.
The terms of conditions.
The agreement as such per se indicate that it was only for 50 ಫ್ಲಾಟ್ 8.5 ಕೋಟಿಗೆ ಅದು ಬೇರೆ ಅವ್ರಿಗೆ ಅಗ್ರಿಮೆಂಟ್ ಕಂಪೇರ್ ಮಾಡಿದ್ರೆ ಇಟ್ ಈಸ್ an illusory figure, but basically it was meant for availing the funding from the person.
Right away you could have executed the mortgage deed and availed the funds.
I don't know at that point of time, Lord, how the parties were advised. In fact,
Sir, you are
and I
representing
understand.
one party. I am not asking Mr. Patil. I am asking the petitioner.
Normally the parties go by the advice of some advice, but the point is,
But there must be some justification for that.
it is only the borrowing lots which was the reason
But
for.
the terms of the agreement do not support such contention, including the nomenclature.
Nomenclature ಹೌದಿಲ್ಲ ಅದು ಅದಕ್ಕೆ
Even the
contents
terms.
it is an ostensible document for the as a security which has been subsequently cancelled because money is refunded by the developers to the Rajkumari. That is the subject matter of the subsequent latest agreement. So
When
today
it was cancelled.
This was cancelled by a registered document dated 17/12/2021, Annexure F.
When the complaint was came to be filed.
6/11/20. ಇದು 17/12/21.
7 and then. 6th.
FIR register ಆಗಿರೋದು it is on 7/11/21.
So after registration of the FIR, this cancellation was.
ಅಲ್ಲ ಇದು ಸೆಕೆಂಡ್ ಅಗ್ರಿಮೆಂಟ್ ಇವ್ರ ಫ್ಲಾಟ್ ಇಲ್ವೇ ಇಲ್ಲ ಅಗ್ರಿಮೆಂಟ್ ಅಲ್ಲಿ. D803 is not one of the subject matters.
Wait for some time. Here is the
case. The failure to sum of facts. On 14/8/2018, what agreement came to be executed by receiving a substantial amount of savings in both the cases. In both the cases, they have received 49,73,538 and 42,97,500. Sir. Thereafter, what happened is, after receiving the advance sale consideration from us, from who in the agreement of construction, they have.
So before this agreement dated 15/6/2019, the advance amount was already paid.
Yes, Lord. On the date of execution agreement itself, entire amount, this amount which is mentioned, has been paid as sale consideration. More, 80 to 90% has been paid. Then what happened is, from two in the agreement, they have specifically agreed that they will complete the project and hand over the portion by December 2020. Then this was not completed. Then another agreement was executed in favor of Rajkumari for the total consideration amount of rupees 8 crore 10 lakhs. 8 crore received as advance. Then we came to know and filed a complaint. Thereafter
8 crore was received by Rajkumari.
This is the third party.
Wait.
Another party in favor of second sale agreement was executed in respect of the properties in respect of which agreement.
No, he refers to the name of Rajkumari.
Please, she is the third purchase.
So,
yes.
Agreement holder. Agreement holder.
She paid 8 crore 10 lakhs, 8 crore to them and 10 lakhs was the balance in the sale agreement. Out of 50 flats, the flat number C806 was mentioned. Flat number 803 was not mentioned.
D803.
Subsequently, we approached the RERA for our refund of advance sale consideration for the reason that the entire project has been abandoned by the developers. The RERA court has passed an order on 9th November 2022, in which a shocking fact has been revealed that the entire project has been mortgaged to Reliance Housing Finance Limited, who have initiated the proceedings under the Surface Act. A postal notice has been issued in their favor. So one flat, 3 purchases. Can you appreciate this?
Copy ಕೊಡಿ.
First, it is mortgaged to Reliance. They have defaulted in repaying the amount of mortgage. Therefore, they initiated the proceedings in the Surface Act. Then they have executed an agreement to us and their consideration substantial amount. Then after that, they have executed an agreement saying in favor of Rajkumari. From 3 persons, they have collected the money, and from 2018 to 2026, project not completed, advance amount of the sale consideration to the respondent number 2, in spite of the order by the RERA authority on 9
November 2022, not repaid, and even after lapse of 8 years, neither advance repaid nor project completed. Kindly see your the findings, reasonings assigned by the RERA, that your the para number 20 of the order, it is mentioned that must be kindly see para number 20.
But this development, Lords, I'm personally not aware because parties are not briefed. I will, Lords, respond, Lords.
It has been brought to the notice of this authority that Mrs. Reliance Home Finance Limited has issued a question notice under Surface Act against respondent promoters, project highway fees, and had further issued sale auction notice on 6/12/2021, which published on 8/12/21. Now, my lord, according to law, once the question has been taken, these persons have been dispossessed and the property is mortgaged to the financer, and question has been taken by the mortgagee, they become the owner of the property. So even after lapse of 8 years, in spite of order of the RERA, neither my advance repaid nor project has been completed. They have abandoned the project, abandoned the entire project, and borrowed the money from 3 persons on one flat. If this is not your cheating, then nothing can
Lord,
be.
what is being submitted is beyond the papers available before the court. Lord, this is new thing which is brought up.
No, there's nothing new.
No, nothing new. Correct. Whether this order has become final, I'm not.
Sir, your party is at fault. He was required to
Complete the project. I admit all that.
No, he should have apprised you. You cannot find fault with the
No,
other
I'm not
side.
saying that. Now, Lord,
He's putting forth the facts of the case.
Lord,
Why you are finding
matter
fault with him?
Matter is pending from
If
last
at
2
all-
years.
If at all your client has cheated you also,
ಅದಕ್ಕೆ ಒಂದೇ ಒಂದು ಆರ್ಡರ್
shows the conduct. Conduct
No,
of the
I agree.
petitioners.
No, this is not a case of scuttling the investigation further. This is a case of fraud with the innocent purchasers. Let the investigation go on. Let the matter be investigated, because 3 persons whose money has been siphoned off by the petitioners here. They have no intention to give money of anybody else.
So that can be ascertained subject to that.
They can't say that they are innocent.
Only one request. Only one request. This document which is produced now, whether this order has become final or not, I will certainly ascertain. Monday ಇಟ್ಕೊಳ್ಳಿ ನಾನು ಹೇಳ್ತೀನಿ. ಆಮೇಲೆ ಅದು ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ.
ಇವತ್ತು ಯಾವ ಧೈರ್ಯದ ಮೇಲೆ ನಿಂತ್ಕೊಳ್ರಿ ಸರ್ ನಾನು ರೆಡಿ ಅಂತ. ನಿಮಗೆ ಫ್ಯಾಕ್ಟ್ಸ್ ಗೊತ್ತಿಲ್ಲ.
ಅಲ್ಲ ಫ್ಯಾಕ್ಟ್
ಯಾವುದು ಗೊತ್ತಿಲ್ಲ. But still you are ready.
ರೇರಾ ಡೆವಲಪ್ ಅಲ್ಲ.
ಎಷ್ಟು ಟೈಮ್ ವೇಸ್ಟ್ ಆಗಿದೆ ನೋಡಿ.
I owe an apology.
ಬಂದಾಗಿಂದ ಇಂಥ ಕೇಸ್ಗಳೇ ಬಂದಿದೆ.
I owe an apology. ಇದು ಈಗ ರೇರಾದ್ದು ಏನು ನಮ್ಮ ಸ್ನೇಹಿತರು ಹೇಳ್ತಾ ಇದ್ದಾರೆ. I will ascertain whether this order has become final or not. ಮಂಡೆಗೆ ಇಟ್ಕೊಳ್ಳಿ ನಾನು ಸಬ್ಮಿಷನ್ ಮಾಡ್ತೀನಿ.
Tell me about facts. I will ignore that. Come on. What are the grounds for quashing?
Now, so far as the
According to you, it is the mortgage deed.
ostensible agreement ಅಂತಾನೆ ಹೇಳ್ತಾ ಇದ್ದೀನಿ ನಾನು.
Terms of the agreement do not support that.
ಅದಕ್ಕೆ ನಾನು ostensible ಅಂತ ಹೇಳ್ತಾ ಇರೋದು.
Yes, then what are the grounds? The first ground I am not
subsequently
convinced about that. Second one.
Subsequently, the agreement which is alleged against me that I have entered into 50 ಫ್ಲಾಟ್ಗೆ ನಾನು 8 ಕೋಟಿ 10 ಲಕ್ಷಕ್ಕೆ, ಇಲ್ಲಿ ಒಂದು ಫ್ಲಾಟ್ಗೆನೆ 60-70 ಲಕ್ಷ ಇರುವಾಗ 50 ಫ್ಲಾಟ್ಗೆ 8 ಕೋಟಿ ಅಂತಂದ್ರೆ ಇಟ್ಸ್ ಓನ್ಲಿ ಫಾರ್ ದಿ ಪರ್ಪಸ್ ಆಫ್ obtaining funding from the person, which has been subsequently cancelled.
Sir, you are the signatory to the agreement.
No,
yes, you cannot go beyond that.
Therefore, I am making a submission insofar as the D803 is concerned. Now, my learned friend is bringing up another point that it is not a subject matter of the second agreement in favor of Rajakumari. And the first information says that my apartment is sold, agreed to be sold to some other person. Adu date hakta illa, but anyway, I have produced the document. That document shows that D803 is not the subject matter of the second agreement, which was for purpose of taking funds from Rajakumari. Subsequently, that has been cancelled by another registered document.
Where is that agreement?
There is Annexure F, page 75.
Entered into with?
By Rajakumari has executed in favor of the.
She is the co-accused, sir.
Please.
She is the co-accused. What about the respondent?
ಇದರಲ್ಲಿ ಅವ್ರದ್ದು FIR ಇಲ್ಲ ಈ ಕೇಸಲ್ಲಿ.
See, I am not concerned with the dealings between you and Rajkumari. I am concerned about his complaint.
His complaint ಅಲ್ಲಿ 1122 ನಲ್ಲಿ Rajkumari is not.
How I am concerned about your agreement, cancellation of agreement with Rajkumari.
Kindly see the array of accused at page 13. ಅದರಲ್ಲಿ ರಾಜ್ಕುಮಾರಿ ಅವರು ಇಲ್ಲ.
ಒಂದರಲ್ಲಿಲ್ಲ ಇನ್ನೊಂದರಲ್ಲಿ
ಅದಕ್ಕೆ.
See, we are concerned about the complaint given by respondent.
Second respondent in
you
this
are
case.
answerable to that. Now we are seeking to quash the criminal proceedings initiated on the basis of the complaint filed by the respondent.
Second respondent in 1122. I'm confining my submissions for 1122 for the time being. To submit that D803, which is agreed to be sold in his favor, is not the subject matter of. So ಹೀಗಿರುವಾಗ ಈ FIR in
2 grounds you have highlighted. Only 2 grounds.
2 grounds that ಇದು transaction.
Any other ground?
Transaction ಆಗಿದ್ದಲ್ಲ ಕಂಪನಿ ಇಂದ ಆಗಿದೆ. Company is not made as one of the accused, and in fact I have a ruling. I will ಅದು ಈಗ ಬಂತು ನಾನು ನೋಡ್ಬಿಟ್ಟು ಹೇಳ್ತೀನಿ ಅಂತ ಅದಕ್ಕೆ ಹೇಳಿ. ಇಲ್ಲಿ ಕಂಪನಿ
ಇವತ್ತು ಏನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಿ?
ಅಲ್ಲ ಅದಕ್ಕೆ
ನೀವು ಸೈಟೇಷನ್ ನೋಡಿಲ್ಲ, ನಿಮ್ ಕ್ಲೈಂಟ್ ನಿಮ್ಗೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಕೊಟ್ಟಿಲ್ಲ, ನಿಮಗೆ ರೇರಾ ಕೋರ್ಟಿಂದ ಏನು ಗೊತ್ತಿಲ್ಲ.
ಅದೇ ರೇರಾದೂನು ನಾನು ಸಬ್ಮಿಟ್ ಮಾಡ್ತೀನಿ, ಸೋಮವಾರಕ್ಕೆ ಇಟ್ಕೊಳ್ಳಿ ದಯವಿಟ್ಟು. ಸೋಮವಾರ.
Why I heard you?
I understand. I thought this.
I can understand youngsters ಬಂದು ಏನೋ ಈಗ ಮೊದಲಿಂದೆಲ್ಲ ಮಾಡಿದ್ರು ಹೋಗ್ಲಿ. What about you, sir?
I will assist the court.
ಇಡೀ ಬಾರ್ ಇಂದ ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಈ ರೀತಿ ಆದ್ರೆ ಏನ್ ಮಾಡ್ಬೇಕಿದು?
I understand that the assistance from the bar side is wanting. I'm not saying, but when the new facts are brought in, I will assist the court Monday.
Whatever he says, you are harping upon him. I don't know, new facts. What your client is doing? Why he failed to brief you?
I understand.
Question your client.
I will certainly do that. But this is a new revelation. I will certainly put it across.
ಸುಮ್ಮನೆ ಏನೋ ಒಂದು ನೋಡೋದು ಟೆಸ್ಟ್ ಹೇಗಿದೆ ಕೋರ್ಟಿನ ಮೂಡು ಅಂತ. ಅಲೋ ಆಗುತ್ತಾ ಇಲ್ವೋ ಅಂತ.
ಅಲ್ಲ ಯಾಕಂತಂದ್ರೆ ಅದು because charge sheet is filed there. ನಾನು ಹೇಳಿದ್ದೀನಿ ಸಬ್ಮಿಷನ್ ಕೊಟ್ಟಿದ್ದೀನಿ, ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ ಅಂತ ಹೇಳಿ ನಾನು ವಿಡ್ರಾ ಮಾಡಿದ್ದೀನಿ. ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ ಅದನ್ನ ಸಬ್ಮಿಷನ್ ಮಾಡಿ ವಿಡ್ರಾ ಮಾಡಿದ್ದೀನಿ. ಅದೇ ಗ್ರೌಂಡ್.
ಇಲ್ಲಿ ಕಾಯ್ತಾ ಇರೋದು ಅದಕ್ಕೋಸ್ಕರ.
ಇಲ್ಲ ಇಲ್ಲಿ ಸ್ಟೇ ಇನ್ಫ್ಯಾಕ್ಟ್ ಇನಿಷಿಯಲಿ ಸ್ಟೇ ಇತ್ತು. ಇಲ್ಲ ಒಂದ್ ಸೆಕೆಂಡ್, ಇನಿಷಿಯಲಿ ದೇರ್ ವಾಸ್ ಸ್ಟೇ, ಬಟ್ ಆಮೇಲೆ ಸ್ಟೇ ಕಂಟಿನ್ಯೂ ಆಗಿಲ್ಲ. ಯಾಕಂದ್ರೆ ಪ್ರೀವಿಯಸ್ ಲಾಯರ್ ರಿಟೈರ್ಡ್ ವಿದೌಟ್ ನೋಟಿಸ್. ಆಮೇಲೆ ನಾನು ಬಂದ ಅದ್ರ ಮೇಲೆ ನಾನು ಕಂಟಿನ್ಯೂ ಮಾಡಕ್ ಪ್ರೆಸ್ಯೂಮ್ ಮಾಡಿಲ್ಲ. ತಾವು ಸೋಮವಾರ ಇಟ್ಕೊಳ್ಳಿ, ನಾನು ಐ ವಿಲ್ ಗೆಟ್ ದಿಸ್ ಇನ್ಫಾರ್ಮೇಶನ್. ಯಾಕಂದ್ರೆ ಬಿಟ್ವೀನ್ tomorrow and Saturday I have got some personal difficulty.
December 2020 he is supposed to hand over the question. We are in 2026. If this is not the premeditated intention of the developers to cheat the purchasers, if they should have finished completed the project and they should have handed over.
Yes, what is the stage of investigation? Now there is no stay. He should go on with the investigation. Very serious charges. Unfortunately, we are here to hear all these things.
Similar matter already charge sheet is filed, but in this case also charge sheet will be filed because same 3 purchasers who are friends have booked 3 flats. All the 3 purchases have been clubbed.
Let's say charge sheet be filed, there is no stay. Learned counsel for respondent submits that in connected matters, the charge sheet is already filed. In the connected matters, the charge sheets are already filed. Learned additional advocate general submits that in these petitions also the investigation is almost completed, and at any time the charge sheet could be filed. Next, learned counsel for the petitioner, after addressing the argument for some time, seeks time to get necessary instructions and to make his submission. List for further arguments.
Your Lordship.
Further arguments. Yes, next. 11th.
Serial number 11, Anumesh,
Date ಕೊಟ್ರಾ?
P. Nishal.
Any date?
ಕೊಡ್ತಾರೆ, ಆಫೀಸರ್ ಕೊಡ್ತಾರೆ.
Right. I'll take it late.
Appear for the petitioner, my lord.
Yes.
The offense is the 306, 498A, 506, read with 34, my lord.
306.
498A, 506, read with 34 of IPC, my lord. This
And how many accused are there?
3, my lord. This petitioner is accused number 3, my lord.
What is the relationship?
My lord,
What is the relationship?
there is only, she is not a family member, my lord.
So she is responsible for the death.
The only allegation is this petitioner against illicit relationship ಇದೆ ಅಂತ ಅಷ್ಟೇ ಸ್ವಾಮಿ, ಬೇರೆ.
With accused number 1.
Yes, my lord. The only
Who
allegation.
is A2?
A2 is sister of A1, my lord.
A1 is the husband. Husband Allah. Date of marriage?
Date of marriage is 18/6/2009, my lord.
9.
Yes, my lord.
Date of death?
26/6/2018, my lord.
Complaint by?
Same day, my lord. 26/6/2000.
Sent by?
By deceased mother, my lord.
Deceased had filed the complaint?
No, my lord.
ಇದೆಯಲ್ಲ ಕರ್ನಾಟಕ ಮಹಿಳಾ ಆಯೋಗ ವನಿತಾ ಸಹಾಯವಾಣಿ ಮಹಿಳಾ ಪೊಲೀಸ್ ಠಾಣೆ ಬಾಗೇಪಲ್ಲಿ ಇವರಿಗೆ ದೂರು ನೀಡಿದ್ದು
ಅದು ಎನ್ಸಿಆರ್ ಆಗಿತ್ತು ಸ್ವಾಮಿ. ಅದು
ಅದು ಎಲ್ಲಿದೆ ಅದು ಕಂಪ್ಲೇಂಟು? Undertaking was given by accused number 1. Death note is also there. Death note ಎಲ್ಲಿದೆ? Page number. ಇದ್ರಲ್ಲಿ ಇಲ್ವಾ? ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ವಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ. ಇಲ್ಲ ಸ್ವಾಮಿ, ಲಾಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್ಸ್.
ಇದೇನು ಬೈ ಹ್ಯಾಂಗಿಂಗ್?
Yes, my lord. Yes, my lord. Last date of hearings allu the court has directed to produce the suicide note.
ಕೊಡಿ. ಇದೆಯಾ ನಿಮ್ಮ ಹತ್ರ? ಆಯ್ತದ ಏನಿದೆ ಕೊಡಿ. ಏನು ಡಿಟೇಲ್ ಡೆತ್ ನೋಟ್ ಇಸ್ ಫೈಲ್? ಹ್ಯಾಂಡ್ ರೈಟಿಂಗ್. ಇದ್ರಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್ ನಾಟ್ ಎಟ್ ಫೈಲ್? ಆಲ್ರೆಡಿ ಫೈಲ್. ಮತ್ತೆ ನಿಮಗೆ ಸಿಗದೆ ಏನಾಗಿದೆ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಇದರಲ್ಲಿ they have not.
It is not part of charge sheet?
They have not filed in this. one submission from the past 2 years ಇಂದ ಅವರು suicide note ಕೊಡ್ತೀವಿ ಅಂತಾನೆ ಹೇಳ್ತಿದ್ದಾರೆ. The court has directed from the last 3 dates of hearings, my lord. The previous bench also is directed, my lord.
ಎಲ್ಲಿದೆ ಕೊಡಿ, ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ, ಏನಿದೆ? Was there any direction? There was a direction in the year 2023. ಅಲ್ಲಿ ಇದು ಇಲ್ಲಿ ಇದೆಯಲ್ಲ ರೆಕಾರ್ಡ್, ಅವರೇ ಬಂದು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಬೇಕು ಅಂತಿದ್ಯಾ? ಟುಮಾರೋ ಇದು ಏನಿಲ್ಲ, ಇದು ಎಷ್ಟೇ ಡೆತ್ ನೋಟ್ ಒಂದು ನೋಡೋದು. ವಾಟ್ ಆರ್ ದ ಕಂಟೆಂಟ್ಸ್ ಆಫ್ ಡೆತ್ ನೋಟ್?
Only suicide note.
ಇನ್ನೇನಿಲ್ಲ. ಇದು ಕೊಡಿ ವಾಪಸ್. Originals also. Please time to produce the death note and address our arguments this tomorrow.
Grateful, my lord.
ಏನು ಹೊಸವರು ಮೀಟಿಂಗ್ ಒಂದಿದೆಯಲ್ಲ, ಎಷ್ಟಿದಾವೆ ಹೊಸವರು? ಇದ್ಯಾವುದು? 2 ಲಿಸ್ಟ್ ನಂಬರ್ 1 ಕೊಡಿ. ಏನು ಕರೀರಿ ಇದು?
Store matter, list 1, serial number 2, Dominic James, R.C. Nagaraj, P. Prasanna Kumar.
ಎಸ್, ಎಲ್ಲಿದ್ದಾರೆ ನಿಮ್ಮ ಅಡ್ವೊಕೇಟ್? ಬೆಳಿಗ್ಗೆನೂ ಅದನ್ನೇ ಹೇಳಿದ್ರಿ, BC ಮೇಲೆ ಬರಲಿ ಅಂತ ಹೇಳಿದೆ.
ಇಲ್ಲ, ಅವರು ಸ್ವಲ್ಪ ಅಲ್ಲಿ ಸರಿ ಇಲ್ಲ.
ಯಾರು ಸರಿ ಇಲ್ಲ?
ಅವ್ರು ಎಲ್ಲಿ ಸರಿ ಇಲ್ಲ ಮೇಡಮ್, ಹಾಗಾಗಿ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ 1 ತಿಂಗಳು ಬಿಟ್ಟಂಗೆ ಕೊಡಿ. ಕರ್ಕೊಂಬಂದು ನಾನು ಕರ್ಕೊಂಬಂದು ಮಾಡಿಸ್ತೀನಿ ಮೇಡಮ್.
ಯಾರು ನಿಮ್ಮ ಅಡ್ವೊಕೇಟ್ ಹೆಸರೇನು?
ಜೇಮ್ಸ್ ಅಂತ ಮೇಡಮ್.
James D.
ಡೊಮಿನಿಕ್ ಜೇಮ್ಸ್.
ಹೌದು ಮೇಡಮ್.
Petitioner ಜಯಣ್ಣ. ಏನು, what is the order you are saying? Investigation.
From one police station to CID. There was a direction, there was an application made by the concurrent members to transfer the investigation from Sadashivanagar police station to CID. Thereby acting upon that application, the magistrate has passed an order and that was under challenge in criminal.
Now investigation itself is stayed.
Investigation itself is stayed from 2016. Whether earlier what had happened, 3 FIRs came to be registered. This is the question of.
ಕೊಡಿ, ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ.
3 ಮೇಡಮ್, ಯಾಕೆಂದ್ರೆ ಅವರು ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಸದಾಶಿವನಗರ ಪೊಲೀಸ್ನವರು ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಕೋರ್ಟ್ಗೆ 3-4 ಸರಿ ಹೇಳಿ ಕಳಿಸಿದ್ರು, ಬಂದಿಲ್ಲ ಮೇಡಮ್. ಅವ್ರಿಗೆ ಮರ್ಯಾದೆ ಕೊಟ್ಟಿಲ್ಲ. ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಅವ್ರ ಕೋರ್ಟ್ ಅವರು CID ಅಂತ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ. ಅವ್ರ ರೀಸನ್ ಇದೆ ಮೇಡಮ್. ಅವರು ಪೊಲೀಸ್ನವರು ರೆಸ್ಪಾನ್ಸ್ ಮಾಡಿಲ್ಲ, ಮರ್ಯಾದೆ ಕೊಟ್ಟಿಲ್ಲ. ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಕೋರ್ಟ್
ಬನ್ನಿ ಪ್ರಶಾಂತ್. H.M. Jayana, the petitioner party in person is present and submits that his advocate Dominic James D. address the arguments on the next date of hearing. The petition is of the year 2018. I do not find any reason to adjourn the matter. Next, Leonard additionally also submits that the connected criminal petition is filed by the state impugning the order passed by the London magistrate. The incident had occurred during 2016. The investigation is not proceeded with till date. Considering all these facts, the petitioner is directed to address his argument either personally or through his advocate on the next date of hearing without fail. This time, tomorrow.
ಮೇಡಮ್, ಆಕ್ಚುಲಿ ನಮ್ದು ಅವರು ಜಡ್ಜ್ಗಳು ಚೇಂಜ್ ಮಾಡೋಣ ಅಂತ ಇದೆ ಮೇಡಮ್. ಹಾಗೆ 1 ತಿಂಗಳು ಟೈಮ್ ಕೊಡಿ ಮೇಡಮ್. ಯಾಕಂದ್ರೆ ಸಾರಿ, ಲಾಯರ್ ಅಡ್ವೊಕೇಟ್ ಚೇಂಜ್ ಮಾಡ್ಬೇಕು.
ಭಾಷೆ ಮೇಲೆ ಕಂಟ್ರೋಲ್ ಇರಲಿ.
ಸಾರಿ ಮೇಡಮ್,
ಏನಂತ ತಿಳ್ಕೊಂಡಿದ್ದೀರಿ ನೀವು?
ಸಾರಿ ಮೇಡಮ್, ಅಡ್ವೊಕೇಟ್ ಚೇಂಜ್ ಮಾಡ್ಬೇಕು ಮೇಡಮ್.
ಏನು ಜಡ್ಜ್ ಅನ್ನೇ ಕೊಂಡ್ಕೊಳ್ಳೋರ ನೀವು?
ಇಲ್ಲ ಮೇಡಮ್, ಅಡ್ವೊಕೇಟ್ ಮೇಡಮ್. ಸಾರಿ, ಮಿಸ್ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್. ಓದಿರೋದು ಕಡಿಮೆ ಮೇಡಮ್, ಪ್ಲೀಸ್ ಮೇಡಮ್, ರಿಕ್ವೆಸ್ಟ್ ಮೇಡಮ್. 1 ತಿಂಗಳ ಟೈಮ್ ಕೊಡಿ, ಯಾಕಂದ್ರೆ
1 ತಿಂಗಳು ಕೊಡಲ್ಲ ಸರ್.
ಸರ್ಟಿಫಿಕೇಟ್
ಹಾಕಿ
ಮೇಡಮ್. 15 days ಮೇಡಮ್.
ನೆಕ್ಸ್ಟ್ ವೀಕಿಗೆ. ಎಸ್,
15 days ಮೇಡಮ್.
ಅದರ್ವೈಸ್ ಇಟ್ ವಿಲ್ ಬಿ ಡಿಸ್ಮಿಸ್ಡ್ ಅಷ್ಟೇ.
ಅಭಿಪ್ರಾಯ
ಹಾ, ಅದೇ ಮಂಡೇನೆ ಕೊಡ್ತಾರೆ ನೋಡಿ. ನೆಕ್ಸ್ಟ್
ಮೇಡಮ್.
9ನೇ Radhikayam, Jayashree Narasimhan.
Your Lordship, one humble submission. I may be permitted to amend the, yes, Your Lordship. This was, I heard in detail, Your Lordship.
ನೀವು ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಮಾಡಲ್ವಾ?
ಮಾಡಿದ್ವಿ.
ಮತ್ತೆ
ಎಲ್ಲ ಹಂಗೆ ಅಲೋ ಮಾಡಿದ್ವು ಲಾಸ್ಟ್ ಟೈಮ್. That's
a procedure to be followed.
Yes, Your Lordship. I'll follow the procedure.
Compromise with that.
I'll follow the procedure, Your Lordship. Kindly permit me to amend the.
I will not permit. You have to file an application. What is the amendment?
I'll do the same thing. I'll file an application, Your Lordship.
Counsel for the petitioner, place time. Next. Very strange ಅಪ್ಪ ಇದು. ಏನು ಕೋರ್ಟ್ ನಲ್ಲಿ ಇದೀವೋ, ಸಂತೆಯಲ್ಲಿ ಇದೀವೋ, ಅದು ಏನು ಗೊತ್ತಾಗಲ್ಲ ನನಗೆ. Everything is permitted. ಅದು ಏನೋ ಲವ್ ಅಂಡ್ ವಾರ್ ನಲ್ಲಿ ಎವ್ರಿಥಿಂಗ್ ಇಸ್ ಫೇರ್ ಅಂತಾರೆ. ಇದು ಕೋರ್ಟ್ ನಲ್ಲೂ ಎವ್ರಿಥಿಂಗ್ ಇಸ್ ಫೇರ್. ಏನೇ ಮಾಡಿದ್ರು ಫೇರ್. ನಾವು ಏನಾದ್ರು ಹೇಳಿದ ಕೂಡಲೇ ವಿಲನ್ ಆಗ್ತೀವಿ. CPC, CRPC ಯಾಕೆ ಬೇಕು? ತಗೊಂಡೋಗಿ ಎಲ್ಲರಿಗೂ ಸಮುದ್ರಕ್ಕೆ ಎಸಿಬೇಕು.
My apologies.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಮೆಟಿಕ್ಯುಲಸ್ಲಿ ಫಾಲೋ ಮಾಡ್ತಾ ಇದ್ರೆ, ಇದು ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ಕೋರ್ಟ್. ನಥಿಂಗ್ ಬೈಂಡ್ಸ್ ದಿಸ್ ಕೋರ್ಟ್.
I'll file an
ಅಲ್ವಾ?
necessary
We are
application.
constitutional authorities. We are above law. ಯಾವ ಪ್ರೊಸೀಜರು, ಯಾವ ಲಾನು ನಮ್ಮನ್ನು ಬೈಂಡ್ ಮಾಡಲ್ಲ. We can do wonders.